right.
Pardon of the same matter.
No.
Then give one.
Is also 80 years of old, my lord. What has
See, I am taking only 20 matters in a week. And if there is a holiday in a week, it will be February.
May list this matter next week. It may be 1 week after.
Yes. I don't know.
My lord, TRPC, it was directed to list in the month of March, but it has not yet been listed. Actually, the urgent interim order is not passed yet.
Yes, anything else? Pardon to mention, say, is given the CRL number 22 2024. It was Juvenile Justice Act, my lord. Already the co-accused have been on bail by your honorable lordship, my lord. So this matter may be taken up tomorrow, my lord.
Not tomorrow.
Pardon to mention, my lord. RSA, there is a RSA with regard to auction of pawn, my lord. The state is proceeding with the auction of our pawn. Sir, weekly hearing the item 10.
Well, I may be, pardon to make a mention out of list, my lord.
Somebody is mentioning.
I have taken concern of my lord and friend, Mr. DP Mahanti. His associate is present, my lord. Item 10, weekly list for hearing. I pray after vacation. Item
weekly list for item 10. Yes.
I pray after vacation.
After vacation? No, 2018 matter not.
No. The last
Finish of I can assure you, if I take up, I'll take up and finish it.
last week.
October 10 days.
How many
October 10 days. Please just as requested by Sri Maheshwar Mathil and counsel appearing for the respondents. Is this matter on?
Week commencing 6th May.
Week commencing 6th May.
Mail the item
6th May. Week commencing 6th May. How difficult
item 13, my lord.
Item 13, yes.
Next week,
all right, as requested by Sri Pondal and counsel with the appellant, list this matter next week.
So, given to the item number 10, on behalf of Mr. H.S. Mishra, I have taken up
item 10, 2011 matter.
H.S. Mishra is appearing for the opposite panel number 3 member.
Yes.
Governing body.
Yes. 2011 matter.
Counter not yet been filed.
Maybe. Counter may not be necessary. 2011 matter.
Next week.
As requested on behalf of Sri H.S. Mishra, release this matter next week.
Opposite
Since this is a case of the year,
3 matter.
Since this is a case of the year 2011, the parties are requested to come ready for final disposal of this case. Yes, Mr. Mishra, you were mentioning something?
My lord, with your lordship's kind permission, out of list mention a transfer matter of the year 2023 where notice has been issued by this noble court. Wife is the applicant here.
Yes.
My lord, the divorce proceeding, I am seeking for transfer to a place where the husband is working. So therefore, my lord, since there is no interim order of stay, now the trial court is proceeding. So I am praying, my lord, this matter may kindly be taken up next week, my lord.
All right.
My lord, I am filing the memo through my associate, my lord.
All right.
My lord, I
Grateful,
filed memo about case and contempt matter, my lord. Other petitioner, it is retired petitioner, is a retired employee.
Yes.
Not getting the pension matter. So,
Yes.
supplementary list item number 1, fresh admission. My lord. This is a my lord against a confirming judge. Regard to a further preparation.
You are not admission that you are not prepared.
No, my lord.
No.
Further preparation.
No.
With regard to covenants of agreement, exhibit 1.
No, not necessary. I've seen whatever needs to be seen, I've seen.
The house will be auctioned, my lord.
Nothing can be done about it.
If there is a chance of settlement loss, if the appeal is admitted, it's a money should not be given. On concern bargain of the opposite parties, IRILA 87 1919 CLT 192 para 4 and 6, and also that Supreme Court decision AR 1986 Supreme Court 1571. It is well settled in law that decision does not operate as judicata
if not decided on merit. It relies on decision of Supreme Court. User law, Supreme Court first also. Decision not being on merit would not be res judicata in subsequent suit when former suit dismissed or deferred. That is rely 1966 Supreme Court 1332. It is settled question of law that for the inadvertent access of the counsel, the petitioner should not be allowed to suffer. The rule of proceeding are intended to serve the ends of justice, not to defeat the dispensation of justice. The interest of justice cannot be defeated technically. It is stated in the counter of the opinion 4 in the granting aid shall not be. It is stated in the counter of the opinion 4 in counter that GIA granting aid shall not be claimed as a matter of right. In this context, it is submitted that GIA cannot be matter of right, which has been decided in full bench of the Honorable Court. The only exception that has been made that there should not be discrimination and relief should not be granted arbitrary to the prejudice of a person concerned. I rely 1988 1 Wheeler 588 Jogeshwar Naik versus State of Orissa and others. It is stated by the opinion number 4 in para 4 of the additional counter dated 6/4/2024 that the claim of the petitioner is time-barred claim. In this context, it is stated that the principle settling law that the government passed the order providing benefits of the servants with retrospective effect and at times even 10 years before so. Therefore, it is always presumed that when a person is in service and he demands arrear of salary or differential salary during the period of service, it cannot be said that his claim is time-barred. It is a recurring cause of action accruing day by day, and at any point of time, the payment of the arrears of salary or differential of the same can be paid to the government servant without considering the period of which the payment is sanctioned. Rely 2005 to Wheeler 610. It is stated that the rule which said that the court may not inquire into the belated stale claims is not a rules of law, but a rules of practice based on sound and proper exercise of discretion, and there is no inviolable rule that whenever there is delay, the court must necessarily refuse to entertain the petition. Rely 1974 Supreme Court 259. The principle decided as reported in 87 1990 CLT is squarely applicable in this case. I will cite it afterwards I will cite that decision I have within me. It is settled question of law that technicalities of limitation should not prevail over the cause of substantial justice. Procedural law held any provision under procedural law should not be construed in such a way that it will leave a court helpless. Procedural law is not a tyrant but a servant, not an obstruction but an aid to justice. Even if in case of unintentional lapse of the part of the litigant should not normally cause the doors of the judiciary permanently closed before him, the effort of the court should not be one finding means of pull down the shutters of the adjudicatory jurisdiction before the party who seeks justice on account of any mistake committed by him, but see whether it is possible to entertain his grievances if it is genuine. That is Supreme Court 2002 Wheeler 492 Supreme Court. Condonation of delay. Expression sufficient cause, meaning construed as no hard and fast rule has been or can be laid down by deciding the application of condonation of delay, but over the years the court has repeatedly observed that a liberal approach need be adopted in such a matter so that substantive right of the parties are not defeated on the ground of delay. 2007 scale 230. Another two cases I have filed for one case for headmaster scale of pay. I have also from the beginning of the school, I have the headmaster, but they have not allowed me. I have extracted my service as headmaster, but they have not paid my salary in that regard. So I have filed a headmaster scale pay and another also reverse scale of pay in the year of 1988 as reverse scale of pay was rule 1998 that has been I have another also filed for that. That is separate footing. It is not concerned with it. They have claiming that it is I have that this is the matter. It is concerned to this subject. This is not the concern to that subject. It is separate footing. The petitioner has cited the decisions para 11 in the written note of submission 5 days OBC stating similar circumstances situation employees of other organizations private high schools are allowed by government to draw such area dues prior to excess order level in obedience to order of the Honorable Apex Court. So also this Honorable Court mentioning a date of order Honorable Court with case number as reflected therein with some related documents. Petitioner have never suppressed any fact. The reply of 11 para 11 of the ICNL counter has already been stated in aforesaid paras. Petitioner has prayed to get justice in the light of judgment in para 11 in earlier written note submission of 5 days. The principle decided in the constitutional bench 5 judges. The Honorable Apex Court relating beneficial or applicable to similar persons when benefit is latest judgment arises. That is, I have quoting service, condonation of delay. Appellant prefer representation before the respondent to get benefit of order of the tribunal in earlier cases. Application before tribunal on dismissal of the representation. Tribunal dismissed the application on ground of delay. Tribunal ought to have condoned the delay and granted relief to the appellant's application for appellants granted and a tribunal's beneficial order made applicable to the applicant. Realize 1997-6 Supreme Court 7-1. K.C. Sharma versus others, K.C. Sharma and others versus Union of India and others. Decision of the opposite decision relied by the opposite party, that is 2008 Supreme Court 6-8 is not applicable in case of the petitioner as per the fact and legal aspects as stated in the earlier paras of the written note of submission of the written note of submission of the petitioner. Each case must be considered on its own merit. This is my submission. So I will cite the one squarely applicable judgment which I have relied. May 87 1990 CLT case 192. May can see the first 192 para. First, the opposite parties to pay the year salary they are claiming of the petitioner with effect
Which
of
paragraph? Which paragraph are you?
well, first they are claiming for the salaries to get 1174. The pay of the area wages of the petitioner with effect on 1-1 as per the revised scale of pay 1974 and with effect on 1-81 to 24/2084 as per the revised scale of pay 81. Revised scale of pay 74 এবং 81 দুইটাকে পাওয়া পে they have claimed. They have given an agreement not to claim some that revised scale of pay 1-1 they will get from 77, they were allowed.
No, I get it, I get it. The court held that the agreement between the corporation and the employee will not stand in the way as similar employees have been given the benefit. So in this case, you also claim that similar benefit, similar employees have been given the benefit. So have you filed any details of those employees who have been given such benefits?
Then I have given the written note, para 11 of the written.
No, any document, anything.
Document that is cited is there, so.
Ordinarily, the undertaking given by you would be binding, but if you say that some other persons similarly situated have been given the benefit, where is that proof? Where is that document?
The document I have cited is para 11. Manuel, can you see my written note?
Yes, yes.
Written note submission,
Para 11.
para 11.
Yes.
In the judgment of decision of the honorable courts are relied on. The order dated 16/9/2010 and WPC number 153/59 of 2010 along with order dated 1/12/2011 in
Okay, produce one of those judgments. You have referred to several judgments. You probably.
I have given the judgments in my the counter written note submission
Much. All the judgments of this court.
of this court.
No, where has it been held that the similar employees have to get the.
Categorically stated, and not only this case. Apart from this 2001 matter, we have given 3 number of writ petitions what he has filed, and now it has been clarified by my Lord Senior Matter in this case that there are 3 different cases which he had also filed, and during those periods also, my Lord, in 2001, 2003, in 2010, cases were filed, my Lord, but he didn't take any step with respect to restoration of that particular case. So, my Lord, since a particular prayer which was made in the year 2000 and dismissed for default in the year 2006, I admit, my Lord, it cannot act as a res judicata. But the conduct in which, my Lord, of the conduct of the petitioner by filing this particular writ petition after a period of 6 years of dismissal of default order, and with an observation that because some other similarly situated person got that particular benefit, that will be against it.
All right. We'll continue next week.
Yes.
For further arguments, list this matter next week. You have completed your arguments. I'm just simply adjourning it to next week.
I presented that I have cited some decisions with my written note.
That is there. It is there.
I will give you within a
No, I'm not closing it today. I'm keeping it to. I'm just adjourning it to next week. Next week there will be no hearing, but just it will be.
I will produce that judgment and all this today court. I will.
Yes, please. Yes.
Written note to
It is already there. Yes.
Item note 6.
May please, Your Lordship.
Yes, some
In
documents.
this case, my Lord, the question was that, my Lord, whether this particular one Vasundhari Gunya was actually appointed or not. And our stand is that, my Lord, she was appointed, the post was filled up. Thereafter, my Lord, a so-called notice was issued, and afterward, she was disengaged from service. My Lord, to that effect, even though, my Lord, I had directed them to provide me the originals, but I have got the copies through mail, my Lord. Can I provide?
Yes, yes.
Addition related. And I'm also handing over a copy of this.
What are these documents? What do they say?
The first document is with respect to engagement, my Lord.
Engagement of that
Vasundhari
Gunya.
Yes,
Yes.
ma'am.
Yes.
Then, my Lord, the second one is the joining.
Joining. Yes.
Then, my Lord, the third one is ସେ କାର୍ଯ୍ୟରେ ଯୋଗ ନ ଦେଇ ପାରିବାରେ ଆଉ ଏଠି ଫିଟନେସ୍ ସାର୍ଟିଫିକେଟ ନ ଦେବା ପର୍ଯ୍ୟନ୍ତ କାର୍ଯ୍ୟରେ ଯୋଗ ଦେଇ ପାରିବିନି ବୋଲି ଯୋଉ କହିଲେ
Yes.
ଦେନ୍ ତାଙ୍କୁ ଆମେ ଯୋଉଟା ଡିସଏନଗେଜ କଲୁ ତ ଲାଷ୍ଟ ଡକ୍ୟୁମେଣ୍ଟ ଲିଟଲ ବିଟ୍ ଏଜି
Yes.
on 6/4/2000 the address number of 6/4/2013 and these things have been taken to consideration in our order, madam. So the specific stand of the petitioner, my Lord, that Vasundhari Gunya was never engaged, that is not a fact.
All right. Learned AGA. As directed, Learned AGA. Furnishes, files photostat copies of the documents relating to
Yes.
appointment and subsequent disengagement of Vasundhari Guya, Guiya.
সেটা বসুন্ধরা গুইয়া,
Vasundhara, no, Vasundhari to,
বসুন্ধরি গুইয়া।
Vasundhari Guya. Copy of the instruction has also been, copy of said documents have been served upon Sri Mishra, Learned Counsel for the petitioner. A copy of the same be also kept on record. List this matter next week. You go through and.
My lord, please.
Item number 7. Made regards. This despite notice, will that no counter has been. My lord, my friend will take time or I'll do the matter.
Yes, Mr. Mahathi?
No, man, the minister count to the government.
fact,
I am the.
Sent certain instructions. They have referred to another WPC 17040 of 2018,
Yes.
which was filed by the managing committee of Chitrada Girls High School.
The dispute related to my in this case.
Yes,
That
that
my direction,
instruction I have
Article
got.
15, feel that the managing committee not be fulfilled by the opposite parties. That is the whole problem created by them. Annexure 17, page 38. Since 50 man directed to recall the managing committee because of disputes continue in the school. But time and again that also directed complaint filed, but not children, not constituted managing committee. That is the whole problem for creating disturbance among the staff of this institution, and nobody is caring to anybody. That is the whole problem. And without solving the problem, that BO director will appear the BO every day, but to sign and thereafter attend the school. That is our challenge.
But what about the counter? Will you file counter?
Then we can no
They
problem.
have sent certain instructions. Let me file it after consulting with them an affidavit.
Next week though?
Yes, madam.
Next week. Come next Thursday, in the meantime, you file your counter. Sri Learned AGA submits that he has received certain written instructions and wants to take further instructions in such regard. So he further submits that he would file a counter. List this matter next week. Counter, after serving counter be filed in the meantime after serving copy on the other side.
I have a prayer, my lord. My name may be deleted.
Oh, sorry.
Your name,
That
yes.
is the- that
The
is
name
the
of
problem
Mr.
for me.
John Kumar also be deleted from the cause list
I pray
as well as the
that
brief.
the matter 9619, the batch of matter was disposed of relating to same school. Maybe perhaps the judgment has already rendered by your lordship on the Chari. So that will.
That is a particular two persons. That is particular two persons are fighting for each
In charge headmaster, that was the dispute.
हाँ,
ସେଥିରେ managing committee ପାଇଁ ଥିଲା ତେଣୁ ଏଥିରେ ସେ challenge କରିଛି ସେଟା ଖାଲି judgment 10 ଯୋଉଟା ହେଇଛି reference
That is Solans there. And
It will all depend on what stand they give.
not that count.
Let them take it. Yes.
Item number 8.
Item 8. This where is Mr. Das? So he'll begin. You are reading that
Yes,
para 7.
yes, ma'am.
You are reading from the judgment, isn't it?
Judgment of division bench judgment, my lord,
Yes, sir.
passed by my lord Justice D.P. Mahapatra and Justice E.C. Naik.
That is at
At page 31.
31 of the, yes.
31, that is,
No,
for paragraph 2, I am to place it, my lord. So that
just a minute.
because
I
this
think I have opened the wrong file. 34074 though.
three judgment is in the 880 of 1991.
Writ petition.
Yes, my lord.
No,
In the review petition, that is the annexure.
it has been annexed to the review application.
Annexure 2.
Annexed to, yes, yes, yes.
I will be pressing from running page 31, my lord.
No, you have already placed it up to page 6 and paragraph 7.
Paragraph 5, I am to start.
Paragraph 7. I marked it yesterday. How do you know?
In response to the notice issued, counter affidavits have been filed by the opposite parties 1 and 3. Opposite party number 3 and opposite party number 4 to 11 respectively. Counter affidavit filed by opposite parties 1 and 3, state and the director, highlights the affairs of the efforts made by the present petitioner and others to frustrate the disbursement of the grant in aid to the members of the staff of the institution. In the counter affidavit, it is pointed out that the application for the proposed Sashikanta Mahavidyalaya Uttikiri was submitted on 4/8/81 under the signature of the petitioner. The college was inspected on 10/12/82 and necessary information sheet was signed by Sri Radhamon Jena, the then principal. On the basis of the information sheet submitted to the government by the directorate in accordance with the government order, temporary concurrence for opening of an intermediate non-government college in the name of Sashikanta Mahavidyalaya Uttikiri was granted. The college was again inspected on 16/5/88 for the purpose of grant of permanent government concurrence, and the list of the members of the staff was verified. The details whereof are mentioned in Annexure A by 1. Subsequently, during the year 1998 and 1989, inquiries were made, which according to the director revealed the following facts. Circumstantial evidence indicates that the staff of this college have not actually been paid any salary, although they have been forced to sign their acquittance roll as evidence in support of the payment of salary to them regularly. This has happened because of the intimidation and terrorism adopted by the secretary of the GB and his brother, who is a member of the GB, and affluents and the influenced persons of the village. B. The members of the teaching and non-teaching staff of this college have suffered for no fault of theirs due to the high-handedness of the secretary of the governing body. C. The inquiry revealed that the secretary tried to remove some members of the teaching and non-teaching staff illegally and arbitrarily with malafide from the college, and this is the reason for which trouble started and it continuing in the college. The director recommended that none of the staff of both the teaching and non-teaching staff be removed from the college till a regular governing body is formed and the staff is in column BIB recommended for receiving grant in aid from the government. In the counter affidavit, it is further alleged that on perusal of the particulars, the staff verified on 4 different occasions on different dates, spreading over the 7 years by different officers. The list of the staff, as mentioned in the volume BI, appears to be legitimate and eligible to receive the grant in aid. In the counter, it is also alleged that the present writ petition, as well as earlier writ petitions, where are attempted to prevent the members of the staff from receiving and has filed the writ petition to grant the grant in aid. It is averred in the counter that the petitioner is a subordinate government servant now under suspension and to litigate in his and to litigate is his hobby. It is further averred that the question of petitioner's donationship is under investigation, as allegations have been made that the deposit certificate in respect of the security deposit of rupees 1 lakh placed to the registrar of Utkal University does not appear to be genuine. Opposite parties 4 to 11 have also filed a counter indicating that they are the members of the staff of the institution and have been working there with effect from the day they have joined the institution. They have also urged that the petitioner has no locus standi to file the writ petition as the engagement as the secretary of the governing body of the college has been seized. It is averred that the inquiry conducted is proper and the writ petition is liable to be dismissed. At this stage, it will be appropriate to make a reference to the inquiry report, some relevant extract which are quoted below. Notice was duly served on all concerned to remain present during the inquiry. Services of local police and
I don't think
were also requested.
Sir, I don't think this will entirely be necessary to go through the entire inquiry report. It may not be necessary. Is it necessary?
I'll just,
We'll go to the ordering portion now.
yes, my lord. The first, your lordship may kindly come to page 39. After the entire inquiry, findings have come.
Findings are at page 40, next page, I think.
Like I said, finding is page 39.
That's the inquiry, yes, yes, circumstantial evidence.
Finding. Circumstantial evidence indicated that the staff of this college have not actually been paid any salary, although they have been forced to sign the accountant's roll on as evidence in support of payment of salary to them regularly. This has happened because of intimidation and terrorism adopted by the secretary of the governing body and his brother, who is a member of the governing body and affluent and influential persons of the village. 2. Members of this teaching and non-teaching staff of the college have suffered for no fault of theirs, but due to the high-handedness of the secretary of the GB. 3. The inquiry revealed that the secretary tried to remove some members of the teaching and non-teaching staff illegally and arbitrarily with a malafide from the college, and this is the reason for which trouble started and are continuing in this college. Then the recommendations, my lord. 1, that is, regular GB of the college should be constituted as early as possible. 2, till a regular GB is formed, none of the members of the existing teaching and non-teaching staff should be removed from the college. 3, members of the staff are for the list given below, whose appointments or orders, joining reports, qualifications, etc. have been verified by the Deputy Director, Non-Government College, I, and are due to get granting it from the state government if otherwise found eligible as per the existing granting aid principle. A rejoinder to the counter affidavit filed on behalf of the opposite parties. My may skip over because he has stated that he has attended and you will come to
Paragraph 12, I think.
paragraph 12. We have given the matter our anxious consideration and are of the view that the relief claimed cannot be granted to the petitioner. In compliance of the orders passed by this court, in the earlier writ petitions, an inquiry was conducted by the director, who is a responsible officer in the education department. The inquiry report indicates that all possible efforts were made by the director to notice and hear all who appear to be in some manner or other connected with the dispute. More members of the staff, Sarpanch, and the headmaster of another institution were heard, but neither the petitioner nor his brother Ravindra Jana appeared in spite of the repeated notice, and even though Mr. A.K. Roy, the deputy director, had personally approached the petitioner and tried to persuade him to participate in the inquiry, request was also made to the members of the governing body and villagers to attend the inquiry and to make statement if they so desire. The fact that a magistrate and the police had to be requisition given as indicated of the atmosphere which was prevailing there. As the petitioner failed to participate in the inquiry, in spite of the notice and personal request, he cannot now raise the grievance that he was not heard in the matter. If he wanted to say anything, it was open for him to appear before the director to put forth his grievance and plead his cause. Having not done so, he cannot now raise any objection. As stated above, the director is a responsible officer, and there seems no reason for us to doubt this bona fide in conducting the inquiry. The fact that the inquiry was being conducted it seems known to all. This is also evident from the number of persons who appeared before the director. Therefore, we refuse to believe that the petitioner was not aware of the inquiry, involved any disputed question of facts, etc. My lord, this is the report, this is the judgment of the Honorable Division Bench, where they have gone through the entire documents and come to a conclusion that the inquiry was conducted and not only once, on various times, 6 or 7 times, and after that they come to the conclusion who are the genuine staff of the college, and it was admitted, it was accepted by this honorable court in the honorable division bench that salary was not released, acquaintance on the signature has been obtained under force on the threat of losing the service, and the petition, and these people are styling themselves secretary so as to grab the grantee rate of the employees of the institution, which is sanctioned by the government for their payment purpose. At this juncture, my lords, at this juncture, I would like to submit. If the notice would have been issued by, because opposite parties they have described. Now, at this juncture, you also can have a look to one thing. How the game has been played. Writ petition.
Have you given a copy to the other side?
You also can have a look to WBC 5316 of 2020.
This one which you.
No, I'm going to read that. Much has been said about the order passed by the honorable single bench, which was challenged before the appeals court, before the honorable division bench. I would like to draw my how the game has been played. Your lordship can come to running page 19 of the writ application.
My judgment?
No, minus that writ application. Yes, my lord, that judgment.
You are referring to the judgment of the
Judgment of single bench.
Yes, the judgment is there before me.
Yes, ma'am. Judgment of 3378.
Yes. 3378.
Not in that writ application.
Judgment on 3378.
My lord. It has जो फाइल 5316 अपना डिस्पोज करता
हाँ सही अपन कोर्ट लिखे क्वेश्चन
19 सर
page 19 of the writ petition. Writ petition is not here.
नहीं
The writ petition also says yes. 5316 तो
सर हाँ
5316
number 378 हाँ writ petition of 5316 he has annexed WP, that is annexed page 19.
Page 19, yes.
Yes, ma'am. This was a writ application filed by Jatindra Das.
Yes.
Who was the principal cum secretary of Shantilata Mahavidyalaya. In that case, my lordship have already said an application was filed by Shantilata Jala, bringing to the notice of the honorable court that I have filed one application that I have filed and GIA case. I filed a GIA case. That GIA case is pending. That is why I will be affected. I may be hurt. Their lordship took it that since you have filed, you will be hurt. However, a word has been there that as opposite party. That is why I cannot question now right or wrong with she has been made an opposite party number 4 described in the cause title. And what has been described? Shantilata Jalla, that is the secretary of governing body of Shantilata Degree Mahavidyalaya. Now, your lordship, the order has been passed. This order of honorable single judge was said to have been filed as a matter, as a review by said the opposite party number 4. Your lordship can now come to the review petitioner, page 29.
Yes.
She has described herself all right as per the as opposite party number 4 has been described in the cause title. Now your lordship can come to opposite party number 4 at page 30.
Yes.
As I know little, sir, if an order of the court is to be reviewed, those who are parties in the writ application as parties or opposite parties, they are to be made parties in the review petition. Can we look to the, who is opposite party number 4, sir?
Jatindra Das.
Jatindra Jana, son of Jatindra Das, son of Gopal Chandra Das, principal of Santilota Junior College, Jyotikiri. Principal Junior College, Jyotikiri was not the party or not the petitioner before this honorable court. And this order wanted to be reviewed. However, my lord, it has escaped everyone notice. Since it has gone, I cannot now question. I wanted to see the intention, the malignant intention of the authorities to somehow or other to escape all the problems. She wanted to place for the first time that Jatindra Das is the principal of Santilota Junior College. Well, by that time, your lordships have decided there is no junior college or senior college, there is only Santilota Mahavidyalaya. However, my lord, this was not entertained because the order is at page 31. This order was after this, and appeal was filed. Your lordship can see what she has described as opposite party number 4. Again, principal of Santilota Junior Mahavidyalaya. He was not the party before in the writ application which is appealed against. By misjoinder, by non-joinder, by the not disclosing the fact that has been that has been made, and however, my lords, I cannot now question because the judgment has been passed as for inquiry. Now the question comes, my lords. Now, if the matter would have been notice would have been issued, then I would have brought to the notice of this honorable court that the prayer made in the present writ application, which your lordship have directed for disposal by the state government, can your lordship have a note to Annexure 7 series? Very innocuously he said that I made an application before the state government, and your lordship, since all the facts were not disclosed, without your lordship passed an order that this should be disposed of. Your lordship can come to page 55.
Yes.
The prayer includes, it is there for third paragraph. It is therefore humbly prayed that the granting a public broadband sanction and release after 1/7/2009 in favor of the following employees, namely, we taken out, deducted. If a right has accrued, my lords, according to me, we have been receiving salary from 2009. You want that the salary should be taken out and it should not be given. We are supposed to ask for the directions given by this honorable court on verification of record. And we have been receiving, we have been approved and continuing. This is you want to take out without making them a party, my lord. The GI has filed in 330 of 2009. These people were parties there. But now he wanted that, and that GIA having a dispute now, that is an FAO. Now, since you are not able to get any order directly the way you could not have, because without making them party, by indirect process, my lord, by circumventing the procedures of law, he wanted to obtain an order from my lord that my application, with a very innocuous prayer, so he has made a prayer. What is the wrong in it? Innocuous prayer, many days, many people are making and accepting without expressing any opinion in the merit of the case, that the application that is filed before him before this government be disposed of. By that, what happens, my lord? A person who is not the secretary and who has been declared and his secretary that has been rejected by the court of law, he has challenged that and pending in the FAO. No interim order has been passed, and there he has made them as parties, challenging that they should not get the approval, and he is incompetent, my lords. I have already seen that if you are not the secretary of your member of the governing body, you have no right to challenge that if the persons are approved, and they are approved pursuant to the honorable division bench order. and Honorable Division Bench has accorded the approval made by the director. All these things are, my lords, have been taken away from my lord's knowledge. And now they wanted that 18 persons who are receiving the salary are to be denied their salary. What you now do? Look here, I've got an order from the Honorable High Court. Honorable High Court has passed order that you have to decide it. Since no decision, he filed a contempt petition, my lord. That my order passed by this Honorable Court has not been complied. Then your Honorable Court has, without expressing an opinion and merit of the case, directed. That means a handling has been given to him. He has got the handling that unless you comply what I say, I file a contempt, and he filed a contempt. My humble submission is all these facts, and more particularly, you also can see the certificate given by the petitioner in this writ application. Filing of APO 442-10 has not been mentioned, not even the body of the writ application. Because once you have filed, you have to make all the people as parties. Your Lordship, the Honorable Appeals Court, fortunately, the judgment of the 3 judges, wherein 2 of the judges are from this High Court. My Lord Justice G.B. Patnaik, S.N. Pukam, they are from this place. And S.N. Badia. Your Lordship, let us not bother much. Your Lordship can come to para 18. Whereupon the Honorable Court can entertain a issue a writ of mandamus.
Yes.
Coming to the third question, my Lord,
Yes.
which is more important from the point of consideration of High Court's power for issuance of mandamus. It appears that the Constitution powers the High Court to issue writs, directions or orders in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of any of the rights conferred by Part 3 and for any other purpose under Article 226 of the Constitution of India. It is therefore essentially a power upon the High Court for issuance of the higher prerogative writs for enforcement of fundamental rights as well as non-fundamental or ordinary legal rights which may come within the expression for another purpose. The power of the High Court under Article 226, though are discretionary and no limits can be placed upon their discretion, it must be exercised along recognized lines and subject to certain self-imposed limitations. The expression for and other purposes in Article 226 makes the jurisdiction of the High Court more extensive, but yet the court must exercise the same with certain restraints and within some parameters. One of the conditions for exercise power under Article 226 for issuance of the mandamus is that the court must come to a conclusion that the agreed person has a legal right which entails him to any of the rights and that such right has been infringed. I pause it for a moment. What regard she has got, my lord? She described that I am the ex-secretary. She is not making this governing body who is the authority and who has submitted proposal as a party. He has not, and she has not taken the persons against whom she wanted to file cases that the granting is to be taken out. And she has not disclosed the fact that her status as a secretary has been denied by the competent court of law and to which she has filed an appeal and that is pending. At this stage, my lords, can any direction could have been issued? All these facts could not have been brought to the notice of my lords. Had that been, notice would have been issued because I am a necessary party, my lord. I would humbly pray, my lords, hear this matter. I do not want that the matter may be taken for hearing. The order passed may kindly be recorded. Although, my lords, there that the state.
There are 2 things. First is, I have heard you on merits extensively. Now, there is one small technical thing, which is that limitation. You have to place the limitation.
Sir, there is only 4 days limitation.
4 days.
Only 4 days limitation.
Okay.
In fact, my lords, this limitation of because of my ignorance, I confess myself, my lack of.
Actually, 2 days.
2 days.
2 days.
Two days.
Pointed out with SR, we will go with the SR. So we'll call on it anyway. About the maintainability, though Mr. Das has already initial at the first instance, if I remember, when I was first hearing this matter, he had raised a issue of maintainability. That also you will have to address.
Yes, but I have clarified the matter. Who is he? Who
Or
is?
maintainability of review application at your instance. That is what he has said.
I'm a party. I have been made a party, but I have not got the chance to press my case. Had it been so, my lords, I would have brought to the notice of the Honorable Court the game that has been played to keep the matters away from the knowledge of the Honorable Court.
You are opposite party number? What in that case?
Sir,
You claim to be governor.
wrongly described. First of all, governing is until the second is until there is, I have been wrongly
এটা হচ্ছে আমার অ্যাপ্রুভালটা প্রিন্সিপাল কাম সেক্রেটারি অ্যাপ্রুভাল
Your Lordship, Your Lordship will kindly say, এটা করতে করে দিলেন। The latest position I have indicated in my note. Till to date, my lord, there is only one governing body, there is one principal, and college is functioning in one premises.
ସେମାନେ রং রেজিস্টার করছেন
If that is so, my lord, how could they have a wrong description and obtain an orders, my lord?
রিভিউ পিটিশনার হচ্ছে
Well, anyway, so this is your submission now. Mr. Das is not there. Yes.
রিভিউ পিটিশনার
Tomorrow, madam, they held up in court number 1.
Tomorrow we'll continue. No problem. I have said that I'll continue day by day.
রিভিউ পিটিশনার হচ্ছে প্রিন্সিপাল
All right.
Only one.
At this stage, my lord, the review petition, I'm the review petition, he is the principal who was filed as the.
Yes. Mr. Patnaik?
In fact, my lord,
I'm supporting this case, sir. If they will go against that, then I'll file a contempt against you. Your stand.
my lord, my submission, my lord.
Division bench has approved your statements.
I think, my lord, it is my duty to bring it to your lordship's notice, my lord, in this case. That, in fact, your lordship passed an order. And since your lordship took into consideration the different documents which are placed, so I was going through the order, my lord, of your lordship. Up to para number 4, it is only the different decisions what it has been taken in different cases.
Para number 4.
Up to para number 4.
Yes.
It has been quoted.
It was dictated in open court.
Yes, without indicating anything, my intention to show
No merit, nothing on merit. I have not said anything.
my submission.
And you have said a point without expressing any opinion on the
Yes.
merit of the case.
My intention to say, my lord, that your lordship had not indicated anything about the status of the petitioner in that case. So since your lordship only pointed out at the para number 5 and onwards, that petitioner has submitted a representation. So that is why the respondent 1 has actually directed to consider the representation. So now this order is sought to be reviewed, my lord, in this review petition. So I just wanted to add, my lord, that during the pendency, since there was a contempt event, as it has been pointed out by my lord, senior man, this order has been implemented in the meantime, rejecting the grievance of the petition.
That's a different issue, my lord.
That is in the second part, it is
the cases.
So I think, my lord, that is what it is required to be placed before lordship.
Yes, yes.
No, if then review, because that is what he is saying about the maintainability, Mr. Das, if I remember correctly, because the cause of action doesn't remain any further, because rightly wrongly an order was passed and that has been implemented.
হ্যান্ডেল মিলিয়ে
So and you have to challenge it.
So all the facts which has not been disclosed, that has been, now you will take that the honorable court directed. Your lordship's order will be, he will take just hangover to that. Your lordship have not given any order.
I have not given anything on file.
But that will be taken a rider that my lord has passed order. My lord, for the better adjudication, your lordship must hear it.
What will be the legal position when the order has been implemented? How can we reverse it now?
Now, my lord,
Some direction was issued by this.
your lordship have passed that, your lordship have not passed any order, but you have given a seal to the application filed by him, by her.
It was an innocuous order. She had filed a representation. That representation was directed to be disposed of.
That is, there is my, that the show pinches. That representation has nothing to do so far the college is concerned. Your Lordship have seen that the Honorable Division Bench and this court number of
So now what do you, but legally speaking,
my submission, my humble submission is my lord. My lords may hear the matter. That's why
if the order has already been complied with, you cannot reverse. I may recall my order, but then that order, what will happen to that order?
That is what my submission is. And if the review petition will be allowed, then the second case will be in process. If the second case is there, my lord, that it is for adjudication, then the review is in process.
my lord, both the cases will be hard together. It has a link with each other.
Another point also, my lord, I just want to bring to lordship notice that the representation when he had submitted, that is why my lordship, I think, my lord, had consciously note that petitioner without indicating the status.
No,
Because-
status has been named.
In the first title, my lord, she has stated that ex-secretary.
So what?
And sir, who approves support, sir?
I just thank you.
And in the representation mentioned as secretary. And we have stated in our rejection that as per the incumbency, she was never the secretary. So that is why there are two cases.
So that has been challenged by
In the second case.
Mr. Das has challenged it.
Yes, there is-
Sir, if you defend that order, how?
Sir, without, my lords, in that event, without, because that the very locus is will be in the question, my lord. Because that writ petition is also not maintainable. Because now she will get a handling. I am not challenging anything. I am challenging the order passed by the state government pursuant to the order of this honorable court. She will get a handling.
Let us hear Mr. Das.
My difficulty is, if she gets an handling that my application has been adjudicated, order has been passed, and the state government without application of mine has issued this order, therefore she will get a handling by law. She doesn't have a leg to stand. Now this process, now she will get a rider.
All right.
That is my difficulty. If both the things are had together and common law reach pass, there is no difficulty by law. Otherwise, all that endeavors has been made by this honorable property.
Yes, correct. I was just adjourning it to tomorrow.
No.
There was good.
Matter.
No, your associate.
He was there. I have told him to be there.
Mr. The senior counsel has completed his argument.
Why?
So you will have to start. ଏଇଦିଟା ତମେ ଗୋଟେ କାମ କର ଏଇଟା ରଖିଦିଅ yes Mr. Rath, I mean Mr. DN Rath, you don't file this now. It will got a memo କରିକି file କରିବେ last at the end. Note ଟାକୁ ରଖିଦିଅନ୍ତୁ ବାକି ସେତେ ଦେଇଦିଅନ୍ତୁ so that if you want to file a memo, you file it through a memo so that it will be tagged to the case record. Otherwise ସେ କୁଆଡେ ଯିବ ତ ଖୋଜିବାକୁ ବୁଝିନା।
Let him give the copy of this. No, can note to the copy. It is principal approval.
Yes, Mr. Das.
I have filed a preliminary objection.
In the review
It is
review application. Preliminary objection.
Yes.
Yes.
With regard to the review.
Yes.
My lord, I could not be there to educate my lord with regard to the scope of review. Everybody knows what is the scope of a review. Apparent error on record can only be gone into. And moreover, a party in the case can file a review. If he is not a party, then he is to justify his locus, then only he can file a review. Here, my lord, kindly see the cause title of the case. Governing body of Santilata Mahavidyalaya at post Uitikiri via Basta district Baleshwar presented through its principal cum secretary Manoranjan Behra is the review petitioner. Kindly see the cause title of the writ petition. WPC 5316 of 23.
Yes.
Here, my lord, it was filed by Santilata Jaina, myself, as about 70th wife of Satrun Jaina, ex-secretary governing body of Santilata Degree Mahavidyalaya, Uitikiri,
Baleshwar. OP number 4 in WPC 3378 of 2010. Who are the parties? State, director, regional director, governing body of Santilata Higher Secondary School, LA Santilata Junior College, Uitikiri, and one Jatindranath Das, who is writ petitioner in WPC 3378 of 2000.
But is there any institution called Santilata Higher Secondary School or Santilata Junior College?
That is the point, ma'am. That is the only point. Because I have categorically taken note of two statement in the cause title itself I have given. That is, I have played extensively where the matter was heard. And my lord, after going through, taking note of all the points, directed the government to take a decision. I have taken, I was opposite party number 4 in WPC 3378 of 2010. And this OP number 5, Jatindranath Das, was the petitioner in WPC 3378 of 2010. So it arises out of that writ petition only. Many things have been stated by my senior, which has nothing to do with this present writ petition or nature of grievance involved. It must get that institution, but nothing to do. I have an answer. I can answer it for days together also, but that is of no use. So for the dispute involved. So therefore, kindly see, can you please, my lord, see the writ petition? Because my lord will know what is the history of this case. Why I am opposing? Here is no locus. This WPC 5316 of 2023 was filed by the OP number 4 in WPC 3378 of 2010. Myself. Who has filed this? 3378, that is it. That order is at page 19, annex 3 of the writ petition.
Jatindranath Das.
My lord, kindly see. 3378 of 2010, Jatindranath Das, Gopal Chandra, Principal cum Secretary of Santilata Mahavidyalaya, representing the governing body of Santilata Mahavidyalaya, State of Odisha, Director, Regional Director. It was Bhubaneswar then, by a flux of time. Now there is a Regional Director Baleshwar. Out of 5 regional hegal 3 ta thila, 5 so I have made it Baleshwar. 4 is Santilata Jana. That was the party.
No, Santilata Jana, but Secretary of the Governing Body of Santilata Degree Mahavidyalaya.
My lord? Yes, that is the case, my lord.
You hear it is degree, Santilata Degree Mahavidyalaya.
Yes, that was the
Case.
I am taking it to only because that is the point I am referring to the cause title only. My lord is to understand now at this stage what is the dispute, wherefrom it arises. So 3378 was filed by Jatindranath Das, one Jatindranath who happens to be the principal of Santilata Mahavidyalaya. Then he is styling himself as the Santilata Mahavidyalaya. This was filed in 2010. What he was challenging is the government resolution dated 1/7/2009. That resolution is at page 14, annexure 1.
Yes.
It my lord will call for that file also can accept
It
it.
is there.
No, it is more writ type. It is more writ type. 3378. My lord, my late record, my lord, can you see this is the Government of Higher Education notification 1st July 2009. This was under challenge. Pursuant to the power conferred under clause B of section 3 of the Odisha Education Act 1969, read is para 1 of para 3 of the Odisha non-government colleges, junior colleges, higher secondary school granting order 2004. The state government do hereby notify the following 13 educational institutions as aided educational institution to receive block grant in term of the provision of para 3 of the said granted order. Serial number 1, Baleshwar, Santilata Degree Mahavidyalaya, Uitikiri, present college, so and so, so and so. So this is the notification. Santilata Degree Mahavidyalaya notified as an aided institution from 1st July 2009. My lord, no, section 3B says every institution has to be notified under section 3B to be an aided institution. So this is a separate institution that is called Santilata Degree Mahavidyalaya. History of this case was, so there was Santilata Mahavidyalaya established in 1980 with IA classes. In 1987, degree classes were given concurrence, precognition. It was continued. But the law was changed in 1989 by change of act. It says It is all right. There was one college having IA, BA, BSc like this. But now from 89, there is separation. The 10 plus 2 plus 3 scheme introduced. So thereafter, a junior college and a degree college. So even if those institutions which are having both, because they are old colleges, so they are also directed to separate. Now, I know that Revensa College also, there is a university and there is a, now it is being in Revensa College, degree college, Revensa plus 2 college is continued. Till today it is continued. It's separate college, separate principal, everywhere. These type of old colleges, government or private, it was segregated. So, therefore, the 1980 plus 2, I will use that word plus 2, higher classes, was functioning. That became added in 99. Only plus 2 stream. Had it been one institution, there is no requirement of notifying the institution subsequently, because there cannot be two notifications under section 3P. If it is added, double time to come, unless it is granted withdrawn. So that is an added college, which is getting granted under the old direct payment scheme. And this has been notified only on 1/7/2009, because it is a separate entity. If it is continuing composite also, there is no concept of composite college. That was the first judgment of this Honorable Court in that governing board of DGBK College, OJC number 1784. All these judgments, my lord, note. They are the first judgment of Justice D.P. Mahapatra and Honorable Justice Sinai. So there, they have stated there is no concept of composite college. That dispute was with regard to constitution of a governing body. That judgment was further developed in Anil Sahu case, everything. All the judgment says there is no concept of composite college. Everybody has to segregate it. All the institutions have to separate it. So basing on that, my lord, this notification, because this degree college, though it was initially Sashikanta Mishra, now with the operation of law, it is a degree college, a separate establishment. It has to be notified. The government has notified from 1/7/2009. This was challenged by Jatindra Das, who is the principal cum secretary of the plus 2 college. At this time, I can use that word, plus 2 college, higher secondary school. He challenged it in this writ petition 3378. There, my lord, kindly turn to what is the interim order passed there. First, page 18. First, while issuing notice in the matter, my lord, kindly see what was the interim order passed. 8/4/2010. Hard issue notice to opposite party since the land council for the state accept notice on behalf of copy 1 to 3. 3 extra copy of the writ petition. So and so. Put of this matter. Interim, Miss Case. Considering the submission made, it is directed that block grant proposed to be advanced pursuant to the notification in Annexure 13 to Santilata Degree Mahavidyalaya shall be received by the petitioner college. That is Santilata Mahavidyalaya without prejudice to the rights and contention of the respective parties for the degree wing of the said college. This order shall passed shall be subject to the final result of the writ petition. It is made clear that in the event it is held that Santilata Degree Mahavidyalaya is a separate college, the petitioner college will refund the amount received in the interregnum period during the pendency of the writ petition towards block grant to the state. This was the specific direction while issuing a notice. So now this matter was again heard. What was the challenge? No, there is no concept of composite college. It is one college. Therefore, the notification dated 1/7/2009 is dead. That was the subject matter challenge. It is one college, Santilata. That was accepted by the Honorable Single Judge. Kindly see, madam. The judgment is page 21. My senior has read it out. So what the Honorable Court has held, only first paragraph will see, madam, the prayer. What I am saying, whether it is correct or not, that madam may accept. Page 21. In this writ petition, the petitioner, as the secretary of the governing body of Santilata Mahavidyalaya with decree in the district of Balasore, had challenged the notification number 20496 dated 1/7/9 that I have shown, madam, issued by the Commission of Secretary to Government Higher Education Department, opposite Patna 1, treating the petitioner's college as Santilata Degree Mahavidyalaya with decree under section 3 of the Orissa Education Act, hereinafter referred to as, though the said institution is recognized as Santilata Mahavidyalaya with degree from its inception. So this is the challenge was to this notification, why it is. So ultimately, yes, there is no concept of separate college, it is a composite college. Finding all these things, now it is the concluding paragraph in the rope backdrop, page 27.
Yes.
Para 9. In the above backdrop of the fact of the case, the opposite party number 1 has notified 13 number private education institution as education institution to receive block grant in terms of the provision of the paragraph 3 of the grant order 2004 under heading list of 13 degree private education institution, petitioners institution at serial number 1. However, they have reflected the name as a Santilata degree Mahavidyalaya Utikri, though there is no existence of Santilata degree Mahavidyalaya Utikri. Rather, it was Santilata Mahavidyalaya Utikri. Therefore, this court direct the Secretary Higher Education Department, opposite part number 1, to correct the notification dated 1st July 2007 in respect of the name of the petition institution as Santilata Mahavidyalaya Utikri in place of Santilata degree Mahavidyalaya and release block grant to the staffs whose service has been approved by the opposite parties. So this was the judgment. I had intervened because I was the secretary at the relevant time of the degree college. I intervened, intervention was accepted. I was made to submit. And I challenged this order in a review. Subsequent review order is that was dismissed. Then I have gone to the writ appeal. My challenge was to this order because my ground of challenge was in the appeal. There was no concept of composite college, and moreover, this particular judgment in the another judgment by another coordinate bench has declared this particular judgment to be judgment per inquiry because this has not taken note of the law. But since it has not been set aside because the coordinate bench could not have set aside, so I challenge it because that question was put to me by the Honorable Division Bench at the time of hearing. But once it was declared per inquiry, why you are here? But this was not set aside. So therefore, for this particular case, it continues to be a composite college. Degree college existence has been now taken away by the single judge. That is why I come to the writ appeal. And the writ appeal judgment is page 32, my lord. Relevant, my lord, I will read out that order, page 34.
That also we have seen, paragraph 7 will do.
No, but because the first instance, my lord, objection was raised by my learned friend, Mr. Junior Rath was arguing that case on behalf of that Jatindra and other thing. Now, for him who is appearing, that I have no locus standi because I am Santilata, but the Honorable Court has accepted my locus, allowing me to participate, and this appeal was found to be maintainable. That is first part. If my lord permit, I will read out. Mine. Thereafter, para 6. It is 36, 6 and 7, as my lord have told me. It is not in dispute that the impugned order of the land single judge has been held to be per inquirium by the judgment dated 8th April 2016 by another land single judge in WPC 22530 of 2012, governing body of Abhimanyu Samanta Singhar College versus State of Orissa. The said order of the land single judge was approved by a division bench of this court by the order dated 6 March 2017, writ appeal number 225 of 16, governing body of Abhimanyu Samanta Singhar, so and so. As far as the impugned judgment here is concerned, what is already been declared per inquirium and such declaration having been affirmed by the division bench as pointed out herein before, this court has no hesitation to set aside the impugned order of the land single judge. Accordingly, the impugned judgment is set aside. Then, my lord, what is the effect of this order? Government notification 17/2009 exists. So, what is the corollary, my lord? There is a +2 college for whom the petitioner therein Jatindra Das claiming that I am the Santilata Mahavidyalaya. He continues to be the principal of the +2 college, or he is the college, I will say. But degree college became a separate entity. That is true. And this order has not been challenged anywhere, to my knowledge, by now, subject to clarification. So this order is binding on all. So at this juncture, my lord, only thing open is now, there is a +2 college, there is a degree college. So whatever the degree college to do, degree college staff will get the benefit. That is why if you will go back to that interim order, what is the interim order says? That interim order by the division, by this honorable single judge in that 3378 at the instant, my lord Justice M.M. Das order. Yes. That is at page 18. Again, I will take what it has stated that. But it has stated that if you lose,
Then we have to refund it.
you have to refund it to the government. This was the specific that now, see, once the writ petition was allowed, this interim order merges with that. But once the judgment of the honorable single judge has been altered by the division bench, that means the writ petition was dismissed. So this order now bind upon the opposite party to refund the money to the government. Because now there are two institutions, two set of staffs. So if at all anybody is to get subject to verification by the state authorities, to other person, some other person will get it, because I am claiming that I was claiming that particular case was, I was the president, now I am saying the secretary, because it became added, now the principal will be the secretary. But I was contesting the case, I was opposing the entity of that degree college. We have appointed staff, there are valid staff. So now by this person, by fraudulent means, I will now use this word. They have introduced some other persons during pendency of this case or after disposal of this case, this single bench judgment, because holding to be one institution, writ petitions were disposed of with a direction to the state that you consider the proposal and get it done. Proposal was submitted by the same principal prosecutor who was exposing their projects, get the grantinate in his favor or in their favor. Now the money has been transfused to these persons. Those are not eligible or entitled to. I have given an example in the writ petition also. So these are the issues, but end of the day, what is the effect of this writ appeal order is the prosecutor. Now there is no existence of Santilata Mahavidyalaya. Now college is to be two. One is the higher secondary, because there is a government notification to that effect also. Even if it is Santilata, now it has to be renamed as Santilata Higher Secondary School. That is why I named it Santilata Higher Secondary School. After this judgment, now degree college is separate. Santilata Higher Secondary School or Junior College is a separate entity. So now who has taken the money? Santilata Junior College. He should give it to the government in order to enable the degree college staff to get the benefit. That was the case. So at that juncture, after disposal of all these cases, I have filed the writ petition because I was exposing the cause. Nobody else will come. State will come. State definitely will not come. Because in the meantime, state has given the money to the person. I am not exposing the cause of myself because I was accepted by this honorable court. So I am carrying it forward. Let the judgment be come to a logical conclusion. Whatever the matter is there, I have filed a representation to the government. So look here, these are the facts. So you kindly verify.
That has been rejected.
No, yes, now that is why. No, I am in the first stage. So that is why I have filed a writ petition, because I have filed a representation with these facts, and that writ petition was disposed of by law at the stage of admission. Yes, this is the prayer. Whatever I have stated now, this I have argued before this honorable bench. And on consideration of the facts, I don't think there is no illegality, infirmity, or irregularity in the order passed by this honorable court at the first instance while disposing this 5613 of.
Well, it will continue tomorrow, Mr. Das. Tomorrow. Heard arguments. Heard further arguments in part. Let's this matter tomorrow. Bye. With the understanding that a little bit only matter so. I think I've heard more than 1 hour. 1 hour 15 minutes. The other matters are there, so.
9.
Item 9.
On behalf of Mr. S.N. Sharma, kindly playing for adjournment, madam.
What? Well,
Filing of requisites.
well, 2011 matter. Some order was passed. There is no fresh notice. Have you taken fresh notice? Fresh notice on opposite matter number 3. Requisites for issuance of fresh notice not received. Received showing service of 2 extra copies. Complied with the order of this court.
Tomorrow I will.
No, why tomorrow? Why not now? This order was passed on 21/3/2024. Directing you to take fresh notice. You are till date, you have not filed your requisites.
Tomorrow.
No, I will dismiss it. The order dated, by order dated 21/3/2024.
Tomorrow.
Office note says that it.
And he doesn't inform. Yes. Item 11.
I have given the copy to
Yes, Mr. Rai, what is this matter?
my lord in the
What was the last item?
My lord, which I am for the opposite.
This is your-
My lord, upon page 20.
You have received
Yes, my lord.
petition.
In,
You are ready for the counter.
my lord, in course of the day, I received a copy, my lord. Today, my lord.
This order was passed on 1 month back.
so unfortunately I could not.
And so unfortunately, this will be dismissed.
Lordship, kindly go to your lordship, just 24th, Anasa
No,
5.
will you file any counter? No. Is it necessary? Or you are ready to, I'm ready to,
Yes, it's not necessary, my lord.
not necessary. Yes, what is it, what is your prayer, what is your case? Upon the petitioner, she is meritorious, physically handicapped candidate by crossing the merit list by dimension 5. Yes, What is the fact, Mr. Ryan?
Fact of the case is that, the petitioner, even though he is a first class career candidate and also she has secured the first class mark in the library science and meritorious candidate, but she has not been given appointment, on the contest that, the pretext that she has
Appointment against whom? Was there any advertisement for any post?
Yes, my lord.
they have not advertised, only in the notice board.
No, where is that? Where is that? What, for what post? Koodi kebe? Kona ala kona kisi apno?
Say notice board that has not been given to supply to.
Anyway, but what was it? What was notified?
Notified that to give the appointment to one librarian in Bapuji College, Saraswati Nagar, in the district of Hon'Ble.
Yes.
That was 16, 11, 12.
Yes.
And
You were one of the applicants.
I am one of the applicants, and I have secured more marks than other candidates, and also the.
How do you know that?
The best 24 may kindly see.
He is third, my lord. The first.
Solidarity Sahu.
Solitary Sahu, first class in metric, third class I and BA, second class, first class in library science, and I have secured 17% of career marks. Career marks 17%, other candidates they have secured less marks.
Experience 0.
Max.
But they have stated the experience is 0. But even if I have given, may kindly see page 19.
Yes.
Page 19, that is in obtained under RTM. Academic achievement experience, they have not given anything. Performance of Viva test strictly on the basis of merit. Strictly on the basis of merit. That means merit means as per the education qualification. But they have not given anything in that Viva test, and they have only in order to give the appointment to the.
So who was appointed? Arati Pradhan.
I am the
appearing for Arati Pradhan.
I am for the Arati person.
You are for the Arati.
I in the serial no one.
Who's for the state is the other answering party.
Yes.
No, state has nothing to do in the matter.
Then who the governing body? Governing body Bapuji College. The Bapuji College has to answer, isn't it?
Yes.
Notice was issued.
Notice
notice was
issued, but he is not appeared.
If they are not appeared, we'll pass expertise.
And all sorts of the problem, and he sees created.
His post is third. His man see the your page 24. The another ready also. 5 his serial 5 his.
Let me just find out whether notice has been validly served or not.
Sorry,
One the state appeared. 1, 2, 3, 4. 1, 2, 3 state has appeared.
Yes.
So 4, 5, and 6.
Yes.
Notice on 5 appears to have been served.
5 nobody.
On Arati, it has been served through police.
Yes. I am for the other.
Yes. And opposite party number 5 has already valid services there. Opposite party number 5 is the principal of that college.
Yes.
Governing.
Governing body.
No, not governing body. Governing body is the opposite party number 4. The sub-collector.
The principal.
No, governing body is opposite party number 5. All right. So all parties are present. All parties are present.
No, opposite party 5 is not present.
See, he may not be present, but notice has been served.
4, yes.
If he doesn't appear, what can be done?
4 and 5. But the petition is also physical handicapped person. She is not given any preference. But a physical handicapped person, can see. I have managed the certificate at page 15. Is a physical person, but that has not been taken into consideration, and she has obtained the training.
So where is your application? Did you apply as a physically handicapped candidate?
Yes,
No, it is single post, madam. It is single post of librarian, madam.
that may be, but the physical that should be mentioned in the notice, but that has not been given. Nothing is the notified. And physical handicap is also I have that obtain the training, Lord, but that for that no marks has already given to the
In
petitioner.
single post, there will be no reservation. Since it's a single post, there will be no reservation.
It is librarian post, my lord.
Let us-
Librarian.
Let us come to the selection list. When Arati Pradhan. So your experience, you have secured 0.
Page 16 may can see that training I have taken. Nobody has taken that training, Lord, but that has not been taken into consideration.
No.
And that
not yet.
expense has not been taken into consideration, my lord. That expense has not been taken into consideration.
That is not the experience.
And the under
Experience means experience of working as a librarian elsewhere.
I applied for under RTI Act, Miller, but nothing has been given to me, Miller, by the principal. By the principal, Miller. Can you see other things that answer 5 series, Miller? Under RTI Act, I wanted to obtain the documents, Miller. The principal did not give.
What document did you seek?
Well, every document, Miller. So far, the interview is concerned, Miller. And nothing has been given except all the 3 to 4 documents only. Nothing has been given, Miller.
So on what ground are you challenging your non-selection?
Well, my experience certificate has not been taken on consideration that.
Your experience, that is not an experience certificate.
And Miller,
That is a qualification, extra qualification certificate.
and the other things, under what circumstances they have given that experience certificate and other documents what I prayed for giving under RTI that has not been supplied to me, Miller. And nothing has been done.
You should have challenged that before in an appeal under the RTI Act.
No.
Under the Right to Information Act, you should have challenged it in an appeal.
That is favorable, but the performance, the bias strictly on the basis of the merit.
Merit mean? Some question पता से answer करे same size mark दिया अभी का पहला वो कौन?
किसी को समझाए, nothing. That's a good.
That's a different.
And moreover, that physical handicap certificate has not been taken into consideration department, and the certificates those who have been given, my experience certificate that has not been taken into consideration. Nothing, Miller. And for which, Miller, the principal knowingly neither given appearance before the Hon'Ble Court nor given any counter, Miller. The principal should give the all sorts of documents, Miller.
What document will the principal give?
The documents
You are a non-selected candidate. You have not been selected. You are an unsuccessful candidate. How can you challenge the selection?
But because there is some with a malafide intention, they want malafide intention.
But you have no experience, so you have scored 0 in experience.
But I have a meritorious candidate. I have all the candidates.
No.
And there is no in the advertisement. If the advertisement had stated that some marks will be given to the particular merit and so also experience certificate will be given to the some marks. Nothing that
You do not have an experience. Show the experience certificate. Where is that experience? What you are referring to is a qualification or a training. That is not experience.
And in the meantime, nothing has been given.
No, sorry. I will not interfere.
It will come Monday. I will give the certificate.
What certificate? You have not given in the writ application since 2013. Now you will give the certificate.
No, I will take the instruction from that candidate.
What?
Whether the stage already given anything or Mangland can the principal may be directed to produce all sorts of documents.
Why?
So that the matter will be submitted before the Hon'Ble Court with merit that how they have done all these things.
The selection committee has assigned marks. Why will this court think that these marks are wrongly given?
Well, because there is no.
So you must have come. You should have come to the court with primacy. Like for example, you have been given 0 in experience. You should have come with the experience certificate saying that sir, I have applied, I had submitted this certificate. Ignoring this, they have given me 0. But what your certificate you are showing is only a apprentice certificate, which is not experience. Experience means experience in that post. And you have also not enclosed the notification which came out in the notice board. That advertisement.
They have not given the notification. Only they notified.
That is missed because my lord, paper publication also, my lord. Some bad.
দেখি কোনটা ସେଥିରେ କିଛି ଲେଖିନା ଏକ୍ସପିରିଏନ୍ସ କଣ ଲେଖାଯିବ କେମିତି ହବ କଣ ହବ ନଥିଂ କ୍ରାଇଟେରିଆ ରିଟନ୍ ଟେଷ୍ଟ ହବ ମେରିଟ ଦିଆଯିବ କି ଭାଇବା ଟେଷ୍ଟ ହବ କୌଣସି ନଥିଂ
Persons having requisite qualification may attend interview along with all certificates, testimonials, original / experience if any. What does it mean? Plainly means experience as librarian in any other place. সেটা যদি আপনার হচ্ছে দেখুন না will call for the record.
ମୁଁ without experience I have secured more marks ଭାଇବା ଟେଷ୍ଟ ତାର ହବ ବୋଲି କୋଉଠି ଲେଖା ନାହିଁ ତ ଭାଇବା ଟେଷ୍ଟ କୋଉଠୁ ଆଣିଲେ ସେମାନେ
କି ସମତି ଭାଇବା କଲେ ସେ ଟେଷ୍ଟ କେମିତି କରିବେ 5 ଜଣ ଆପ୍ଲାଏ କଲେ କେମିତି ଟେଷ୍ଟ କରିବେ
ଟେଷ୍ଟ ଷ୍ଟାଣ୍ଡାର୍ଡ କେମିତି
नो नो
ମାର୍କସ ନମ୍ବର ନା ହେବା ନାହିଁ
ମୁଁ ପଢି ଦଉଛି persons having requisite qualification may attend interview ଜାଣିନଥିଲି କଥା ଆଜି ନୂଆ ଶୁଣିଲି ମୁଁ ବି ଇଣ୍ଟରଭ୍ୟୁ ପାଇଁ ଦେଇକି ଆସିଛି ଜାଣିଛନ୍ତି ନା ହଁ ବିସିଏସ୍ ପରୀକ୍ଷାରେ ଇଣ୍ଟରଭ୍ୟୁ ଦେଲି ଫୁଲ
ଲେଖାଯାଇଛି ଇଣ୍ଟରଭ୍ୟୁ ଭାଇବା ଲେଖାଯାଇଛି
firing from 18 machine guns.
No, I know that, but that is written भाଇବା ଆଉ certificate verification କେମିତି ହବ
My knowledge in law does not go that far, Mr.
interview
Sorry, sir.
I will face the interview that
No, there's no merit in this case. Yes, I'm passing the order.
ଆଉ ଗୋଟେ ଚାନ୍ସ ଦିଆଯାଉ ମୁଁ ତାକୁ ସେ ଲୋକ ବୁଝିଦେଇ କହିବି ଲେଡିଟା ତ ଫିଜିକାଲ ହ୍ୟାଣ୍ଡିକ୍ୟାପ୍ ଲେଡି ଲାଷ୍ଟ ଚାନ୍ସ should be given to her
Proper material instructions.
material instruction ବହୁତ very poor lady
Some of the poor. Certain part. List this matter next week. As learned counsel to the petitioner wants to take some instructions from his client. Next week. 9th May. Will come on 9th May.
9th May ରଖନ୍ତୁନି
No?
ନା ଯଦି ରଖିବେ 14 କି 15
9th, 16th.
ହଁ
16th May. Item 12.
My lord, in this case, my lord.
Affidavit. E-file.
My lord, I'm filing because I could not file my lord through e-file. Only for the reason, my lord, I was under the impression that it is coming, it was to come, my lord, yesterday. So.
No, this matter on 25th April.
24th आगे कोर्ट में वो कोई रहूंगी नहीं बोली
Anyway, move.
Give a copy.
Yes, sir. I'm giving. ମୁଁ original ଟା କୋର୍ଟ କୁ ଦେବି ସବୁ ଦେବି ଆପଣ ମାନଙ୍କୁ ଦେବି ମାନେ I am actually filing my lord two sets of counter affidavit. One is from the government, another is from the collector.
Collector has filed it separate. Collector is not a party.
Collector is not a party, but your lordship had directed to furnish a report by the collector.
By the order dated 14/9/2022.
It is in compliance with the order of the.
Oh, that's Akram to do.
Yes.
Oh, I remember. Yes. Very good.
মানে collector's report first. ମୁଁ ରଖିଲି ବର୍ତ୍ତମାନ ସବୁ ପହଞ୍ଚେଇ ଦେଇଯାଇଛି। Today my lord ମୁଁ 6ଟା ଧରିଛି 8ଟା ଧରିଛି ମୁଁ ନିଜେ କନଫ୍ୟୁଜ ହେଇଛି ଓରିଜିନାଲ ଟା ମୁଁ ଦଉଛି।
Then I will say that you are filing those and we'll take it up.
Yes,
Cool on our tomorrow. Tomorrow.
Yes, sir.
We'll take it up tomorrow.
Yes.
Kali habo.
Sir, এটা
Tomorrow.
collector
Tomorrow there is a reference, so there is a otherwise very heavy pressure. Already in the meeting we also go through the counter and do make sure. As directed, Sri S.N. Patnaik LGA files a counter affidavit and the report of the collector Baleswar
So that is also through affidavit.
In the form of affidavit in court after serving copies on the other
Yes.
side. Stop. And counsel for the petitioner requests for some time to go through the counter and the report in order to make his submissions. List this matter on Call it. 9th May, Mr. Mishra. Yes, Mr. Mishra, 9th May. Our copy do the file code.
Item 13.
May I please, your lordship? My lord, I have already filed the rejoinder and as well as also the date chart, my lord. Also serve the copy to my lord.
Vision data scanning, but. Yes, what is this matter?
My lord, before I going through the fact of the case, my lord, kindly have a glance on the date chart, my lord.
Date chart, have you given a date chart?
Yes, my lord.
Nicola? We don't have the date chart.
In person.
Along with the rejoinder, perhaps she has filed.
Yes.
Vision or secretary. रो सेटा रखते हैं ऐसा नहीं मिसाल तमें इरा रिजॉइंडर बात कर
Day before Easter day.
नहीं काउंटर फाइल करते हैं रिजॉइंडर
Rejoinder.
इट इज नॉट देयर ऑन रिकॉर्ड तो ऐसे तो टाइप है नहीं तो आई एक्स्ट्रा कॉपी अच्छी दे दो of the date chart.
No, my lord, no.
Date chart extra copy कौन
In pursuance advertisement in brief, my lord, also there undated 23/12/2015 advertisement was published, my lord, inviting the application from the eligible candidate.
what that option from social science to language. Now, after this reject list is produced, you say that due to ignorance of detailed eligibility criteria, I have applied for the post of TGT Arts under social science category, but now I want to change the category.
But my lord, it is my inadvertently committed an error.
No, inadvertent still actually, but it has the right proper. How can one know that?
Till the publication of a rejection list, I knew that I have applied for the post of a TGT language, my lord. It is not my deliberate intention, my lord, my lord.
That will be very difficult. It is very difficult. This is a mental thing. How can you know what was your intention?
Well, they have given.
Since you failed there, you may have changed it. Who knows? You should have brought it to the notice of the authorities.
Well, after the publication of a rejection list,
Anyway, so you submitted your representation. What happened?
Thereafter,
They rejected it.
no, my lord, they have not considered my representation. Thereafter, they published the provisional merit list, my lord.
But they had invited all objections by 4/4/2016. Yes.
Well, since
Please come to just a moment. Please come to paragraph annexure 4.
Yes.
In persons of the environmental
50.
A draft list is prepared and hereby published inviting objections within 15 days. 4/4. So on 4/4 she has submitted a representation. The thing is that her name doesn't find place in the reject list. Rather his name.
Because of that mistake that she has committed.
page number 35,
He has
his
come-
name was reflected.
47. 47 kai? 2 pages.
35, page number 35, my lord.
Page number 35. 34 पर 37 वाला नहीं. 7 पढ़े? ना. ये हाथ फैल दे. अच्छा नहीं. Only one optional in social science. So she was asked to submit her objection by 4th of April. She has submitted her objection.
He.
Oh, he. But that was never taken into consideration. You invite objections, but you don't take it into consideration. But what can be done? Yes.
A long time has lapsed.
If you look at her educational qualifications, let us
He
see.
is qualified. He is qualified.
He's qualified and he could not have applied for social sciences if he doesn't have studies. So what he says, an inference can be drawn. The authority should have taken, having invited into objections, he should have taken it into consideration.
It could have been brought to his notice.
We will direct the authorities to consider. What do you say?
Yes.
Yes? Because Annexure 3 or Annexure 4 invites applications.
Yes. If she has qualification not in the subject that he filled in, but in another subject, let his case be considered at the time when occasion arises.
No, not occasion arises. Let it be considered. Let it just be considered.
Yes.
But whether you have given it to the district welfare officer, you are supposed to give it to district welfare officer. But whether you have given it actually or not, how do you know?
Yes, I have given, my lord.
How do you know? ये रजिस्टर पोस्ट देले कि हाथ रे देले कि केम देले?
By hand, my lord.
সেই তো অসুবিধা।
Kindly consider, my lord.
No, I will direct the district welfare officer to consider.
My.
Right. Other than that, no mandamus can be issued. The petitioner has approached this court seeking the following relief. Para. The case of the petitioner, briefly stated, is that an advertisement was published on 23/12/2016 by the collector Malkangiri, inviting applications from eligible candidates for their engagement in the post of Shiksha Sahayak. Several categories of Shiksha Sahayaks were advertised. The eligibility criteria notified for the post of BA, BEd and BSc BEd were as follows. कोट कर देबो हैला ये देखिए पेज 29 टू ब्रैकेट लिख देन पेज 29 टू कोट करियो तापर गोटे आई लिखिबे आईटा जो लिखाई सेटा लिखिबे आई लिखरे आई लिखि तापर क्रॉस मार देबे ये पिटिशनर claims to have passed matriculation examination. No, it is matriculation of matriculation examination from Hon'Ble Bhattala, matriculation examination in March 2003, comma. It plus 2 arts though?
Yes, yes, ma'am. Plus 2 arts in the year 2005. Stop. His subjects were English, MIL Odia, economics, political science, education, with Odia as optional. Stop. He also passed BA from Barampur University. देखा जाऊनी को इतने कड़ा को देखें तो दिस इज पेज कितने पेज 14 He also passed BA honors from Barampur University with education and Odia as his elective subjects, with English and MIL, bracket Odia. Stop. His honors subject was economics. Where's your BD certificate? From the Bangalore University, madam.
Yes. he
Base number don't.
he passed the he passed BEd from Bangalore University in the year 2013. So, possessing such qualification, the petitioner wanted to apply under the category BE wanted to apply for the post of BA BEd though. BA BEd,
Trained teacher.
PGT. Since she has both Odia and English along with arts and also had OTET qualification, she intended to apply under the above category. The reject list was published on 1/3/2016 by the collector Malkangiri, wherein the name of the petitioner finds place at serial number 47. Under the category social science. Under such circumstance, yes.
No, I was looking at his age.
Age consider consider relaxation I am not issuing any mandamus. I just say that let them consider. If they भूल ही तो genuine mistake
He is in the qualification, but
unfortunately, at this stage, I disclaimed that the petitioner came to know that he had, while submitting application in the prescribed format, he had wrongly opted for social science instead of language by wrongly darkening the circle meant for social science instead of language. Stop. After publication of the reject list, the district welfare officer also published an order on 21/3/2016 inviting objections from the applicants latest by 4/4/2016. Pursuant to such order, the petitioner submitted a representation addressed to the district welfare officer Malkangiri on 4/4/2016, stating that due to ignorance, he had applied for the post of TGT Arts under social science category, but and that he wanted to change it to language category. Stop. The revised draft list was published on 19/5/2016. But the petitioner's name did not find place therein either. Stop. His representation was also not considered. Stop. Mrs. Jyotsna Rani Tripathi, learned counsel appearing for the petitioner, submits that the petitioner is fully qualified for the post of TGT language, having the necessary qualification. But because of her ignorance, of her inadvertence, filling up the form, she could not be considered under the TGT arts language category. Stop. She further submits that despite inviting objections, the representation submitted by the petitioner was not considered, has not been considered as yet by the authority. Stop. This court finds that immediately upon publication of the, not in soon after publication of the reject list, objections were invited from the applicants by order dated 21/3/2016, copy enclosed as Annexure 4. Stop. The petitioner has also enclosed his educational qualification certificates to the writ application under Annexure 1 series, which would reveal that she has the necessary qualification in language. Stop. Since she has no qualification in any of the subjects under the social studies category, it would be reasonable to suppose that she would not apply under such category, but would apply under the category in which she has the necessary qualification. There seems to be some force in the submissions made by learned counsel for the petitioner in this regard. However, the writ application is therefore disposed. So, furthermore, if any representation was actually submitted as claimed, the same ought to have been considered and disposed of in accordance with law by the authority in view of the order dated 21/3/2016. This court therefore deems it proper to dispose of the writ application, directing the opposite party number 2, directing the District Welfare Officer Malkangiri, opposite party number 2, to take a decision on the representation dated 4/4/2016 submitted by the petitioner, if not already disposed of, and to take a decision in accordance with law within a period of 2 months. Stop. After granting an opportunity of hearing to the petitioner. Stop. It shall be open to the petitioner to produce all relevant documents in support of his claim of having necessary qualification under TGT arts category. TGT
Language.
Arts bracket language category. That's all.
Considering his age also. He has no other
In case
option.
the petitioner's claim is found to be correct, the concerned authority may consider engaging him ଆଉ ତ ଶିକ୍ଷା ସହାୟକ ନାହିଁ ତ in any equivalent in any equivalent vacant post after relaxing his age. That's all.
Okay.
14.
I've prepared a small date chart for your lordship's kind convenience.
It's complete.
Hearings of they have filed their counter affidavit, rejoinder affidavit may not require. The last week they have filed their counter
all.
affidavit. May I place the
They
date?
have become very prompt in filing counter affidavits.
Last week they.
Yes.
May I place the date chart?
Yes.
On 8/5/2007, advertisement was issued for the post of Anganwadi worker of 6 Anganwadi centers, including Ramagara 2 mile, for which I belong, the central area. I belong to the central area. On 11/5/2007, opposite party number 6, though belong to out of the central area.
Who is appealing for opposite party number 6?
Yes, sir. My learned friend. Though she belongs to out of the central area, but submitted her application for Ramagara 2. On 21/5/2007, petitioner submitted her application with all relevant documents and receipt was issued to that effect by the CDPO Buguda, Annexure 2 mail. On 23/5/2007, list of candidates finalized but not circulated publicly. In this list, the name of the petitioner was not found. 6/6/2007, meeting of the selection committee was conducted and selection was conducted for all 6 Anganwadi centers. 7/6/2007, opposite party number 6 was selected for the post of Anganwadi worker of Ramagara 2, even if she does not belong to the central area and the name of the petitioner was not taken into the zone of consideration. 2010-2018.
So this was never challenged.
Well, that was challenged in the year 2019. That I am calling to. Because at that point of time, the petitioner was not aware about the guidelines that out of the central area person cannot be considered for appointment. When 2018 advertisement was issued, that I am placing. 2010-2018 advertisement was issued for the post of Anganwadi worker of Ramagara 1 and the petitioner submitted her application thereafter. 30/8/2018, selection conducted, the opposite party number 5 was selected and the application of the petitioner was rejected since she does not belong to the central area. Then, next. 31/8/2018, engagement order was issued in favor of opposite party number 5. 22/2019, after getting the documents under RTA Act, appeal was filed by the petitioner with a petition for condonation of delay. 11/7/2019, reply filed by the CDPO Buguda stating that the petitioner had not applied for Ramagara 2 central area despite filing of the receipt dated 21/5/2007. 19/9/2009, a petition was filed by the petitioner to direct the CDPO for production of the survey list of Ramagara 1 and 2 Anganwadi centers. 17/10/2019, without considering the above petition, appeal was rejected by the ADM. Here, my lord, the fact remains that initially advertisement was issued for Ramagara 2 central area. I submitted my application along with the opposite party number 6, though she belongs to the out of central area. And without taking my application to the zone of consideration, they selected the opposite party number 6. So at that point of time, I could not challenge her selection because I was not aware about the guidelines. In 2018, another notification was issued for Ramagara 1 central area. Then I submitted my application.
What is the law, Mr. Panda? Ignorance of law? Is it an excuse? ସେତିକି ତ କଥା ସେତିକି ତ କଥା ଆପଣ ଜାଣିନାହାନ୍ତି କଣ ଆପଣ ଏକା କଣ you don't know, you are a seasoned lawyer now, you don't know. I refuse to believe that you do not know.
No, that
Ignorance of law is no
I
excuse.
cannot say that I don't know.
So you know, I also know that I do not know.
And I don't know only that they say serious Allah.
No, I cannot say that I don't know, but here, my lord, 18 when
Existing since 2/5/2007.
Yes.
And this is 8/5/2007 advertisement.
But my lord,
You are supposed to know and you are due to know.
but my lord, fact remains, when my application was rejected on the ground that I don't belong to the central area, then I obtain relevant
Let us
documents.
see on what basis
Order, my lord. The Lashmi can peruse the order, that is at page 39, my Annex 11, page 39. Paragraph 2 may I place, my paragraph 3. Really.
How could you entertain that appeal?
The delay was condoned, appeal was entertained, report was called for from the CDPO. CDPO submitted her reply that I have not applied for Ramagora 2 central area. But your Lashmi kindly peruse Annex 2, that is the receipt issued by the CDPO. And that was
Produce the, where is that order condoning the delay?
But that is not.
Yes, Mr. Patnaik. Produce the file. How can the delay be, how could the delay be controlled? If this is the grounds,
Well, in fact, my lord, may I submit one? Actually, if your lordship will go to the entire order of that ADM, my lord, as appellate authority, the petitioner actually challenged the selection of both the selection process in one appeal, my lord. So, in fact, ADM answered both the selection process case.
that is also wrong. Wrong.
That is wrong.
Appeal in which, my lord, she actually approved before the authority. But
So then you should have made the opposite party number 5.
Yes.
Who is approving opposite party number 5?
Well,
Who are 5 and 6 both?
yes.
Yes.
so, well,
Is it the same person?
yes, no, the two
No,
persons.
2 persons.
No, no.
It's a
Ramgod 1 and Ramgod 2.
Yes.
ଫାଷ୍ଟ ସିଲେକ୍ସନ ହେଲା ରାମଗଡ଼ 2 2007
ସେଥିରେ opposite party number 6 ହେଲେ।
ମୁଁ ଥିଲି।
Yes.
ସେ ଏଠାରେ ଆପ୍ଲାଏ କରିନାହାନ୍ତି ଆଦୌ ଆପ୍ଲାଏ କରିନାହାନ୍ତି ମୁଁ ସିଲେକ୍ଟେଡ ହେଇଗଲି ଦେୟାର ଆଫ୍ଟର ସିନ୍ସ ଲଙ୍ଗ 2018ରେ ଅଙ୍ଗନବାଡି ସେଣ୍ଟର ରାମଗଡ଼ 1 ର ସେ ମରିଯିବା ପରେ ଆଉ ଥରେ ଏଗେନ ସିଲେକ୍ସନ ବାହାରିଲା ସେଥିରେ ମଧ୍ୟ ସେ କ୍ୟାଣ୍ଡିଡେଟ ହେଲେ ଯେହେତୁ ସେ ସେଥିରେ କଟିଗଲେ ଦେୟାର ଆଫ୍ଟର ସେ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ସେ ଅର୍ଡରଟାକୁ
So, the moment your Lashmi can peruse Annex 2,
Yes, I am looking at it.
that I have not applied.
possible to
They have stated
order
that I have not applied for Ramagora 2 central receipt. This is the receipt. And this is the certified copy.
original not
And this is the certified copy of the receipt.
No, let me produce the original file.
That is what I was saying.
And the
Is not in a position of that original one.
No, no, you produce it.
this is the certified copy.
Everything, my lord, it has been clarified, and we have also filed on counter, my lord. But
No, no, is it necessary? The file is not necessary. We can go through the counter and dispose of.
yes, but
All right, all right.
Your Lordship, this is the Xerox copy of the certified copy. Your Lordship,
No,
can peruse the Xerox copy. If the certified copy is with me.
So it must be, so you obtain the file later over. In course of hearing, it is stated at the bar that the petitioner was never an applicant pursuant to the advertisement dated 8/5/2007 for engagement as Anganwadi worker of Ramgad 2 Center.
yes,
Stop. Sri Pandal and counsel for the petitioner has produced. You have the original certified copy?
Yes.
Has produced the original certified copy of a receipt showing a receipt granted by CDPO.
CDPO.
CDPO Muguda. Yes. Showing receipt of her application for Ramagada 2. Stop. In order to appreciate the facts properly, it is felt necessary to produce the original file relating to selection of Anganwadi worker of Ramgad 2 Center. The State Council is directed to produce the file for perusal of the court. List this matter on 9th May. All right.
That certified copy.
certificate copy be kept on record.
My
I have the opportunity to go through the certificate.
Please go.
Kal dekhiye.
that xerox copy is annexed to annex.
Not a minute, beyond DA.
देखिए
और notification है?
TRP और reverse, rated the TRP.
वो official service
Yes, matters will be taken up after recess. Yes, yes. I will continue.
the point is this the one additional affidavit filed by the petitioner. Yesterday, my lord, it has been filed yesterday, my lord, on 24th April 2024.
Yes.
Wherein not only certain new averments, but also some more documents are also relied upon, my lord. So may I take some instruction, my lord, on this?
It is their documents, my lord. I have only annexed, my lord. They are
Filed a affidavit additional.
that is correct, my lord.
You didn't take instructions.
Yes.
सीधा चिल्ला मतलब कॉल दी लॉन्च पर रूल कर दी था अबन कर दी था
See, time
It is particularly para number
because
4, my lord.
yesterday I have solved the copy.
और
It is only, my lord, that whatever documents I have supplied in a similarly situated, my lord, what they have done, my lord, they have disengaged me on the basis of a letter of the.
what I will do is one opportunity because otherwise he may be misunderstood. He may be misunderstood. Why?
But I
Whether the additional affidavit is on record, yes,
yes, my lord, that is on record.
Sri S.N. Patnaik, DGA submits that he has received copy of the additional affidavit filed by the petitioner yesterday and would like to take certain instructions with regard to the amendments made therein along with the documents enclosed. I give you only 10 days time.
Yes.
List this matter on 9th May.
Yes.
Yeah, of course, this is a 2022 matter, but since pleadings are complete, I think on that day.
Because they have been disengaged from job.
No, I know, I understand. Yes.
Item 16.
And for the opposite party. 3/4/2024 lawsuits are directed to take instruction whether at the endeavor to reconcile each other because para 6 is said.
You have already expressed your willingness. Your client has
I have
expressed.
already. Twice, in the meantime, twice they.
Nobody has appeared for the petitioner. Why don't you wait for some time? We'll pass it over. Yes, pass over.
Item 17.
No, item 17 is a transfer petition. The wife is praying for the transfer of the case, matrimonial proceeding from Bhubaneswar to Korapur.
Bhubaneswar to Korapur. Bhubaneswar to Korapur.
All right. These, they have no personal income, they are staying with her,
You are the wife.
married.
You are from Bengal, but residing at Korapur right now. According to your
From beginning, because parents are doing service there, father is retired from that place and mother is in service, she is born and brought up there. Native place is Nagana.
you have filed the husband has filed this proceeding for divorce.
No, my lord, for 12 petition, my lord.
Null and void declares.
Section.
Marriage null and void.
Oh, 12.
Marriage has not been consummated so far.
Marriage has not been present. So there's no point in asking for a settlement.
No,
It has not been consummated.
no. These are charges, allegation and character assessment.
No, my
Then these are
The question is, he's a resident of Bhubaneswar. Now,
both are the permanent resident of Bhuvana, Dhenkanal.
permanent resident, but who are presently
Husband is residing in Bhubaneswar
wife
and wife also reside at Dhenkanal with the mother.
mother is working as service government.
They have received the summons at the Bhuvana, my lord.
Now they are putting the, as because the mother is serving at Koraput, I am staying at Koraput.
Naturally.
Father is residing at Vivara, my lord.
No, no, my father is retiring from the Nalco, Namandudi and residing at.
Kindly have a glance to, my lord, running page number 9 and 10 at the counter. I have already annexed photographs.
In what occasion, what?
Of the marriage, of the Puja committee.
Puja committee.
Durga Puja committee, he is the president. The father is the president. And he is
President, there is no proof, but one Puja committee, one photograph is there. On one occasion.
you not admit then how?
Admit should go.
Before that, I would say. What is the stage of this proceeding? My lord, it is now the turn to evidence by the wife, my lord. Already evidence of the petitioner has been over and the wife has not been given.
Not yet cross-examined.
The evidence has started. I will not transfer this case. I will permit you to appear through virtual mode. If but only when your presence is absolutely necessary, you will appear. Otherwise, through virtual mode, you can appear. Yes, my lord. I have no business. Unnecessary. This will not be.
Only petitioner's evidence is not yet, only affidavit is submitted, not yet served.
All right, it will start now. Cross-examination will start.
Well, that is trouble, my lord. Because she is residing there.
No, I will say that the court will not insist on your personal attendance. But not absolutely necessary. At least once you have to come for
that is
also you will have to come. On every day you don't have to come. Yes, my lord. This transfer application has been filed by the wife of opposite party for transfer of.
Also, my lord, one maintenance petition is filed in
During this present proceeding might have been filed, my lord.
No, might have.
But I have no knowledge in that.
The case number is method MC.
Just a moment. CP number 172 of 2023 filed by him before the judge, family court number 1, Bhubaneswar, under section 12 of the 12 read with section 5 of the Hindu Marriage Act. Stop. It is submitted. The transfer application has been filed on the ground that the petitioner wife has been residing at Koraput with her parents. At Bhuban, my lord. नहीं से जहाँ कोई चीज इंटरफेयर कले भारी असुविधा गया सॉरी मजॉरिटी के इंटरफेयर न कले भारी भलो होता सॉरी ओके एट कोरापुट with her parents. As such, it would be inconvenient as also difficult on her part to travel from Koraput to Bhubaneswar to attend the court on the dates of posting of the case. Sri M.M. Patnaik, learned counsel to the petitioner, submits that looking at the inconvenience of the petitioner wife, the proceeding may be transferred from Bhubaneswar to Koraput. Your good name, sir? Ajay Naik. Sri Ajay Naik, learned counsel appearing for the petitioner, opposite party husband, submits that both parties are actually permanent residents of Bhuban, and the petitioner, the opposite party, is working at Bhubaneswar. It would be difficult on his part to travel from Bhubaneswar to Koraput. It is further submitted that hearing of the case has commenced by way of submission of affidavits. The witnesses are to be cross-examined. Stop. Para. Considering the above facts and particularly having regard to the fact that hearing of the case has already commenced, this court finds no justification for directing transfer of the proceeding from Bhubaneswar to Koraput, particularly when appearance of the parties through virtual mode is possible. Under such circumstances, the transfer application is disposed of, granting liberty to the petitioner wife to seek permission of the court below to appear through virtual mode. Stop. Further, the court below shall not insist upon the personal attendance of the parties unless absolutely necessary. That's the
file is what STM code का file is to mention था. मतलब STM code कोरापुट है वो maintenance case file है.
लेकिन लेकिन आदि तो
एपिक फाइल ही चलता है.
Item 16. Sir,
Manual serial number 16.
yes, yes. Did you take instruction from your client?
No, he do not want to compromise the matter.
All right.
So, it is a TRP matter. Both the husband and wife are residing at a Bhubaneswar separately. The case is at Jashpur. The mother is residing with her child. But she had Jashpur chhadi gaya, Jashpur jai parni. So that he prayed to transfer the case from Jashpur to Bhubaneswar Family Court.
What is your case, Mr. Panda?
Both are permanent residents of Jashpur. Marriage was there, they are staying. Bhartan, my lord, as for that, she has come to Bhubaneswar and on rented house she is staying, as per their document they are saying. And she has already admitted the daughter to BJP English Medium School. That is the document which they have annexed, my lord. And I am also, my lord, I am as an ITA fellow and I am in a garage, car garage I am working, that is. And I am also staying at Bhubaneswar, Naharkanta. And case was filed before that court because they both are staying, she was staying at that time and she subsequently, my lord, in 2018, my lord, she left the house and then the case, matter was tried to be compromised, but
Now that both of you are staying at Bhubaneswar,
both she is saying, it's because she is
we can bring it to Bhubaneswar.
yes, my lord, there is no, I'm not obstructing that. But thing is that now she is staying in Bhubaneswar, suppose she will go to another place thrown again. She is doing like this. That's why I'm saying.
Supposing she files an application for transfer again, then supposing the court rejects it on the ground that earlier also she had appeared.
Oh, I don't worry. So that's right. And let's if she's that she has specifically mentioned that she is ready to come, but let's see the attitude of the wife.
Petitioner.
And my wife.
Anyway, you cannot force anybody to
I cannot force my lord.
The transfer application has been filed by the wife of opposite party. Is seeking transfer of CP number 103 of 2019.
Only one thing, my lord, maybe taken out tomorrow so that I can take instructions whether is a 2019 my lord application. Any evidence has been taken or not, I have no idea.
So no evidence has been taken.
That says saying, but my lord, I don't have an idea. So I'll maybe take out tomorrow so that my lord I can be disposed of. If evidence has been taken out.
Sir, transfer to TRP. Jashpur to Bhubaneswar.
No, that the previous case I said because it was to be transferred from Bhubaneswar to CORAM.
Yes, my lord.
So this case,
Let's look at that. Yes,
absolutely. Since both of you are residing at both, transfer of civil CP number 103 of 2019, pending in the court of Learned Judge, Family Court, Jashpur, to the court of Learned Judge, Family Court 2, Bhubaneswar. Said case has been filed by the opposite party husband for divorce,
my lord.
Divorce.
Under section 13 of the of the Hindu Marriage Act. Stop. The transfer of the proceeding is sought on the ground that the petitioner wife is residing at Bhubaneswar since 2011. And then
2011, 2011.
And subsequently lived at Bhubaneswar since year 2011.
Wrong.
Further, a female child has been born to her on 24/3/2013, who is studying at Bhubaneswar. It is submitted by learned counsel to the petitioner that looking at the above facts, it would be highly inconvenient on the part of the petitioner wife to travel to Jajpur from Bhubaneswar to attend the court on the dates of posting of the case. Sri Jagjit Pandal, learned counsel appearing for the opposite party husband, submits that the opposite party is running a garage. But not running a garage, I am working in a garage. Achha, he is working in a garage at Kota Khorda. At Moncheswar. At Nahargonda near Moncheswar. He further submits that the petitioner is seeking transfer only to harass him by forcing him to travel to Jajpur. Forcing him to travel to Bhubaneswar. Only to harass him. Considering the submissions as above, and particularly having regard to the fact that both parties appear to be residing in Bhubaneswar, it would be convenient for both of them if the case is transferred from Jajpur to Bhubaneswar. For the foregoing reasons, therefore, the transfer application is allowed. It is directed that CP number 103 of 2019, pending in the Court of Learned Judge, Family Court, Jajpur, shall be transferred to the Court of Learned Judge, Family Court 2, Bhubaneswar, for disposal in accordance with law. That's all.
Notice again, date not fixed, I'm Janu can
Learned Judge, Family Court, the Learned Judge, Family Court, Jajpur, shall transmit the records as early as possible, and in any case, not later than in any case within 2 weeks from the date of production of certified copy of this order. Stop. Further, the Learned Judge, Family Court 2, Bhubaneswar, upon receipt of the records, shall fix a date and intimate the parties. Intimate the parties accordingly. That's all.
Can I pray one thing, my lord, that initial period that endeavor we had made that says opposed to not to join, that can be,
that will cause prejudice. Yes.
Item 18.
My lordship, this application is filed for transfer of suit from Kotak Family Court to Hon'Ble Family. Hon'Ble.
Learned counsel for the opposite party files counter affidavit in the court after serving copy on the other side.
Just now.
Shall be kept on record. You want to argue or you want to take some time?
Time.
All right. Please this matter. Okay.
16th May.
16th May.
Item 19.
Let's say petitioner filed this case for transfer of civil proceeding case from Bhobanipatna Family Court to Raigada. Only ground is that her life in is danger. Kindly see para 9 of the petitioner minor, page 7 of the my petition minor. More than 170 kilometer. And third thing, my lord, kindly see page page 16, Annex 1. There is the order of maintenance, my lord. That's good. Page 16, Annex order order is 5,000 given to the petitioner. Thereafter, opposite party came to the court and this honorable court reduced the amount 4,000, page 20.
Yes.
Thereafter, he has not paid single amount till date, my lord. This is the matter, 2019 matter. Till date, they are not a single paisa. Thereafter, petition filed the execution petition, page 21. This is pending. Opposite party not appearing also there. Page 21 and page 24, another CRP petition is pending before the Raigada, my lord. Therefore, praying for kindly transfer the CP petition to Raigada, my lord.
Yes, Mr.
First
Panda.
of all, there is no threat of any to the life of the, since they have they could have lodged the FIR or not lodged the FIR. Well, regarding payment, my lord, he has paid something.
Something, madam?
That exact, I have no instruction. But just now I
No.
ସେଠି ତ ଅଛି ରାୟଗଡ଼ା କୁ ଆପଣ ଚାହୁଁଛନ୍ତି ଜାଣିବାକୁ ରାୟଗଡ଼ାରେ କେସ୍ ଅଛି କରିବେ
କିନ୍ତୁ ସମାନ ଡିଷ୍ଟାନ୍ସ ଭବାନୀପାଟଣା ଆସିବାକୁ ଯେତେ ଦୂର ରାୟଗଡ଼ା ଯିବା ପାଇଁ ବି ସେତିକି।
ସେ ରହୁଛନ୍ତି କୋଉଠି ରାୟଗଡ଼ା ରହୁଛନ୍ତି
କଲ୍ୟାଣ ସିଂହପୁରରେ।
କଲ୍ୟାଣ ସିଂହପୁରରୁ ରାୟଗଡ଼ା ହେଲା କେତେ?
About my lord 35।
ଆଉ ଆପଣ ରହୁଛନ୍ତି କୋଉଠି? ଭବାନୀପାଟଣାରେ। ଭବାନୀପାଟଣା ରାୟଗଡ଼ା
120 or
what are you doing?
Automobile mechanic, motorcycle mechanic।
You will appear there or କଣ? Otherwise
virtual
virtual ବି ଯେତେବେଳେ ଦରକାର ପଡିବ virtual appear କରିବେ ଆଉ କଣ?
ସେଇଟା କର।
The transfer application has been filed by the wife of opposite party for transfer of CP number 100 of 2022 pending the Court of Learned Judge Family Court to Bhavanipatna to the Court of Learned Judge Family Court Raigada. Said case has been filed by the opposite party husband under section 13(1) of the Hindu Marriage Act. The present application has been filed by the wife on the ground that she is a resident of Kalyan Singhpur in the district of Raigada. Stop further. A maintenance case filed by her being MC number 70 of 2017 before the learned SDGM Raigada has in the meantime and was transferred to the Court of Learned Judge Family Court Raigada and was disposed of with the direction to the opposite party to pay maintenance of rupees 5,000. Stop. Since the maintenance was not paid, the petitioner wife has also filed an execution case under section 128 of CRPC, meaning CRP number 46 of 2023, which is pending in the Court of Learned Judge Family Court Raigada.
CRP 47
Execution of CRP 47.
46 लिखा है जी भीतर
46 is another petition for enhancement of the
47 तो है ना? It is therefore submitted that Land Counsel of the petitioner submits that taking into account all the other facts and looking at the convenience of the petitioner wife, the divorce proceeding should be transferred from Bhavanipatna to Raigada. Land Counsel for the opposite party submits that the petitioner, that the opposite party is a mechanic by profession. Stop further. The distance between Bhavanipatna and Raigada is more than 100 kilometers. It would therefore be inconvenient on his part to travel to Raigada to
attend the court on the dates of posting of the case. Having regard to the rival submissions and the facts of the case, this court is of the view that since some proceedings are already pending at Ragada, in which the opposite party has appeared, and further that the petitioner wife is a resident of Kalyan Singhpur in the district of Ragada, it would be convenient if the case is transferred to Ragada. As regards the apprehension of inconvenience expressed by the opposite party, the same can be taken care of by appearing through virtual mode after seeking necessary permission of the court. Stop. For the foregoing of Learned Judge Family Court, Bhavanipatna, shall be transferred to the Court of Learned Judge Family Court, Ragada. Stop. The Learned Judge Family Court, Bhavanipatna, shall transmit the records of the case within 2 weeks, whereupon the Learned Judge Family Court, Ragada, shall issue notice, shall fix a date for appearance of the parties, and thereafter proceed in accordance with law.
Item 20.
Here because the petitioner filing this case, transfer of the civil proceeding from Bhubaneswar to Cuttack on the ground that 2 numbers of cases between the same parties is pending at Cuttack.
Also to Cuttack?
Yes, Lordship. 2 numbers of cases already pending before Cuttack, my lord.
Then a counsel appearing for the opposite party, you have appeared?
My lord. Lord, I am filing the counter affidavit.
Then counsel for the opposite party files counter affidavit in court after serving copy on the other side.
Yes.
After serving copy on the other side. Same be kept on record. Doctor, you are the wife.
Yes, Lord.
You want it to be transferred from Cuttack to Bhubaneswar?
Yes, Lord.
How many?
My lord,
Because I was between Cuttack and Bhubaneswar, I know.
the difficulty is there, my lord.
Whatever be the difficulty. Whatever may be the difficulty, Cuttack to Bhubaneswar, how many?
Lonely, my lord, the only person who made member is there. And the father of the petitioner always
And her sister is also staying at Bhubaneswar.
You actually appear to that direction, that I will grant you that liberty to move the court below, and in view of the observations that I will make, you will also allow it.
Yes, Lord.
The petitioner wife seeks transfer of CP number 811 of 2023 from the Court of Learned Judge Family Court 1 or 2.
It is not mentioned. I don't know, my lord. I have not. Unless.
I'll give.
Why will you be?
Filed.
You say ground will dismiss for the.
The husband filed that petition.
But you want it to be transferred, so you should say which case.
I have put the notice mail, but it has not been mentioned.
Say mention करना दे anyway. Learned Judge Family Court Bhubaneswar to the Court of Learned Judge Family Court Cuttack. Stop. Said case has been filed by the opposite party husband under section
13.
13. Section 13 of the Hindu Marriage Act. The transfer is sought for on the ground that other proceedings under the PWDB Act being initiated by the petitioner wife are pending at Cuttack. So moreover, she being a lady, it would be difficult on her part to travel from Cuttack to Bhubaneswar without travel to Bhubaneswar, Cuttack to Bhubaneswar to attend the court on the dates of posting of the case, as there is no other male member available in the family to accompany her. Then counsel for the petitioner submits that taking note of such grounds, the proceeding may be transferred. Then counsel appearing for the opposite party has opposed the prayer for transfer by submitting that the proceeding is sought to be transferred only to harass the opposite party. Stop. Para. After considering the rival submissions, and I'm going through the facts stated in the transfer petition, I am not inclined to allow the prayer, as there being no dearth of communication facilities between Cuttack and Bhubaneswar. It cannot be said that there will be any inconvenience faced by the petitioner wife from attending the court at Bhubaneswar. Stop. Further, the petitioner can also appear through virtual mode after obtaining necessary permission of the court. Stop. For the foregoing reasons, therefore, the transfer application is disposed of, granting liberty to the petitioner to.
What happened in the meantime, the wife had filed under section 125 of the CRPC before the Judge Family Court Cuttack, and also filed under section 12 of the DVR before the JMFC 2 Cuttack, and the two cases is pending there. And the husband has already appeared. After receiving the notice from the two courts from Cuttack, they have filed a petition under section 9 of the Hindu Marriage Act before the Civil Judge Senior Division, Nilagiri. So my respectful submission, though the husband is appearing here and filed counter before the Cuttack and regularly attend the case, and the conciliation mediation is going on in the family court Cuttack. So let the case may be transferred from Nilagiri Civil Judge Senior Division and Nilagiri to Judge Family Court Cuttack. And furthermore, the wife is serving as a staff nurse from appointed as Apollo Hospital and residing in a rented house.
Have you enclosed any document?
Yes, in the court below, I have already enclosed.
No, here. Before
here I have not enclosed, but the document is with me.
No, you have to file it. You have to file those documents. Yes.
Yes, Madam, I want to say only there is every chance of amicable settlement. 2022, the marriage was happened, and they have no issue. There is every chance of settlement, and by interference of third party, the marriage is going to end. So, if your lordship allow us for the High Court Mediation Center for mediation, at least once or twice.
Yeah, I'm willing to allow, but he is not interested.
Once or twice, your lordship allow. Then
court cannot force any party to.
Next date can be fixed. If
No,
he not come, if
if it doesn't come out from the bar that there is a possibility of settlement, because this court, why? I'm always in favor of mediation.
there is every,
Day in and day out, I'm referring cases to mediation.
every chance of settlement.
No, but he doesn't agree.
I have contacted his father. His father is a lecturer.
No, but since she.
Father said and the party said he is not interested.
Then I have to take specific instructions.
Yes, I have specific areas. On the previous date, my lord has directed late to take instruction with his family members whether a talk of settlement is going to be made before the mediation center. They have denied the same. Therefore, I am submitting my lord.
Only due to interference of third party, the marriage is going to end. If the High Court Mediation Center once.
Still, you can also, this is not the only last resort, you can also have a conciliation in the.
Yes, the conciliation is going on. In 2 days, both parties are appeared.
2 days, both mediated.
You try your luck there. If you are so much interested to take back your wife and to resolve the differences, you can have it there also.
Only due to the interference of third party only.
Because this court cannot enter.
Yes. Only I want to say, if your lordship permit, for the High Court Mediation Center, all the mediations are there, going properly, mediator are there. If they are influenced, if they take the charge. Yes, or I had already filed my counter. Both the parties, the residents of both the parties are Baleswar, and now due to some this type of problem, husband left his job. He is jobless now, and he is staying at Baleswar, and so that the proper place is Baleswar.
Have you appeared in this DV case?
I had appeared, but I had filed the objection that there should be
Have you moved any application for transfer of those DV cases to Baleswar?
Yes, filed here. I had filed one transfer petition.
What happened to that?
TRP CRL number 29 of 2024.
What happened? What happened?
I had mentioned twice, but the matter was not taken.
Does not come.
Not taken till it. Item number 29 is because in this case, father-in-law, mother-in-law are there, and they are the senior citizens. I saw that I had filed a transport petition there. Marriage was held at Baleswar, district of Baleswar. Both the parties, house of both the parties are at Baleswar. And in fact, wife is not working in Apollo Hospital. Wife is working, but not working in Apollo Hospital. She is now working in Utkala Hospital, and now she is not residing at Cuttack. She is residing at Bhubaneswar.
That is her problem. That is her problem. If she wants to appear at from Cuttack to Bhubaneswar, Cuttack Bhubaneswar is nothing.
Yes. I had already filed.
Just now I had rejected that application. Cuttack Bhubaneswar, there will be no transfer.
No,
I had filed a TRP.
I have filed before Cuttack. In 125 CRPC.
You appear, and he has already appeared. I'll grant you liberty to appear through virtual mode if you can't appear physically, you can appear through virtual mode. And the court below will also not insist upon your personal attendance on each date. Whenever necessary, you have to appear. That's all.
That was in TRPC. Now she filed the TRPC to transfer the CP. But I had filed that section 9 petition.
That is what I'm saying. That is what your case at Baleswar. Baleswar na koi jagah will be transferred to Cuttack.
Dita case it ଅଛି ତିନିଟା ହବ ଆପଣ appear କରିବେ
it will be problem. Husband is now jobless. Then he is working.
No, why is he jobless? Why is he jobless?
He is an engineer. He is a BTech engineer.
Jobless ତାଙ୍କ ଭିତରେ ଏତେ ମନମାଳିନ୍ୟ ହେଲା ଯେ ତାକୁ ସେ ଏତେ ରହିଲା ଅନ୍ୟମନସ୍କ ତାକୁ କହିଲେ ବାଧ୍ୟରେ ତମକୁ ଦେଇଦିଅ ରିଜାଇନ୍ ଦେଇଦିଅ ସେ ରିଜାଇନ୍ ଦେଇଯାଇଛି ଏ ଭିତରେ 1 year ସେ ଚାହୁଁଛି at anyhow let it be settled then after that only interference of third party after 1 year of the marriage
no it will be transferred
ଭଲ ଥିଲା 1 year of the marriage thila, but interference of third party that was transferred.
This transfer application has been filed by the petitioner by the wife of opposite party for transfer of MAT case number 31 of 2023 pending in the Court of Learned Senior Civil Judge in Nilagiri to the Court of Learned Judge, Family Court, Cuttack. Said case has been filed by the opposite party husband under section 9 of the Hindu Marriage Act. Section 9 though?
Section 9, yes.
The transfer application has been filed on the ground that the petitioner is working as a staff nurse in a hospital at Bhubaneswar. Further, she has filed 2 cases at Cuttack under the provisions of PWDV Act. In the said cases, the opposite party husband has already entered appearance and filed counter.
125.
Has filed 2 cases, one under the PWDV Act and the other under section 125 of CRPC.
Huh? Both the cases they have appeared.
Appeared and filed its counter. Then counsel for the petitioner submits that it would be highly inconvenient for the petitioner wife to travel to Nilagiri from Cuttack to attend the court on the date of posting of the case. Then counsel for the opposite party has opposed the prayer for transfer by submitting that the opposite party is presently unemployed and unemployed and wants to take back his wife. But because of intervention of third parties, his family life was ruined. This has caused mental depression, for which it would be inconvenient, for which it would be difficult for him to travel from Nilagiri to Cuttack. After hearing both parties and on consideration of the facts of the case, I am inclined to allow the prayer for transfer, mainly on the ground that two cases filed by the petitioner at Cuttack are pending, in which the opposite party husband has already appeared. In the result, the transfer application is allowed. It is directed that the proceedings in MAT case number 31 of 2023, pending in the court of Learned Senior Civil Judge Nilagiri, shall be transferred to the court of Learned Judge Family Court, Cuttack. It shall be open to the opposite party husband to seek permission of the court below to appear through virtual mode, if so advised. Stop if such by filing necessary application. If such application is filed, the same shall be considered liberally. Stop.
Technically add करें जॉर्ज फैमिली कोर्ट कोटा कोर्ट बिलो बोले क्या है?
No. Further, the court below shall not insist upon the personal attendance of the parties unless absolutely necessary. Yes, what were you saying?
Court below means Nilagiri, not but court below means George family court Kotak.
See, बुझिए नहीं ना, बुझिए ठीक.
And a direction may be given to appear.
No, I will not.
After
As per the Senior Civil Judge Nilagiri shall transmit the records within 2 weeks. जिनको करा दी, इसको करा दी, इसे notice करिए. Yes.
Item 22.
My TRPCR will be comes in his serial.
The other which you have filed. Yes, without address. Yes.
Item 22.
Last occasion the matter was adjourned because despite service of notice, the other side did not prefer to appear.
Item delivered. Postal tracking report indicates that the postal article containing the notice of this case was delivered on the opposite party on 18/4/2024. There is, however, no appearance. This court deems it proper to grant one more opportunity to the opposite party to appear. Let's this matter next week.
No, last occasion it was adjourned for seeking one more chance to appearance of the.
नहीं देखिए से order है.
As you also
खाली लोग कराए थे जे latest tracking report है. जैसे latest tracking report. Interim order to control.
Let's keep it next week.
Next week.
Next week, sir.
9th May.
As you also.
Item 23.
Please, Lordship, this is a matter regarding Jogana Sahayak this engagement from job.
I will take it up and sum up it.
Counter is also necessary.
Yes.
He,
Council requests for some time, request for some time to file the counter affidavit. Let's this matter 16th May. Vacation पर करना.
And already the 2 years is not in the job.
नहीं interim order अच्छी कहीं वस्तु है.
Subject to final.
Last 2 years.
कोई?
A young man.
16th May. Counter affidavit if any be filed in the meantime, interim order to continue.
Obliged to lose.
Item 24.
Correction be made accordingly.
Item 45.
Same.
Item 26.
extension of time.
First time?
No, second time lordship no seteବେଳେ ଆଜ୍ଞା ତା ଦେହଟା ଖରାପ ଥିଲା ରିପିଟେଡଲି ମୁଁ ଟାଇମ ନେଇଥିଲି ସେଇଥିପାଇଁ ଏଟା ପେଣ୍ଡିଂ
Weeks further time is allowed. 27 towards cash security shall be modified to the extent that she shall furnish property surety amounting to rupees 10 lakhs without prejudice.
Time extension
2 weeks further time shall be allowed.
and correction in cost title.
No, the 2 weeks further time is allowed to the petitioner to surrender. Yes.
Correction in cost title wife of son of jagger wife of
ଆମର ଭୁଲ ହେଇଛି ଏଠି।
ନାଇଁ ଆମର cost title.
ଆଗ ତାର ଲେଖା the petition is permitted to it is the ଏଠି କରିବି it's permitted to correct the typographical error in the cost title in court. Yes, ସରିଲା।
ମୁଁ କରିପାରିବି
list item number 1.
Item number 1 was somebody mentioning. ନା ଠିକ ଅଛି ଏଇଟା ଅର୍ଡର ଆସିଛି କଣ ହେଇଛି କଣ ଆସିବ ଅଫିସ ନୋଟ appeal notice issued to sole respondent by registered post with the such notice returned address is long absent hence returned to sender. Order number 5.
The notice is not sufficient. My prayer is, my lord, notice is again.
That should be reissued. Yes. Notice issued to the sole respondent has returned unserved. Issue fresh notice, requisites for which shall be filed within 3 working days. A short returnable date be fixed. List this matter. Vacation for.
So we commencing 24th June.
In the week commencing 24th June.
Item number 2.
Many substitution of the registry pointed out as per number 2 and 6 could not the notice be served. So those to be served again and substitution to be allowed.
Acceptance of additional.
The appeal may be accepted.
What is the note? We have filed over 439 for 24 for substitution, madam, of deceased respondent number 2 and 6.
Nice, madam.
We have filed a composite application for substitution along with acceptance of additional evidence.
Well, that is to be done, it's an old matter. So I that is to be accepted, my
Mr. Hota, you are vastly experienced in civil matters. You please tell me. Put a separate petition of High Court additional evidence of 4127.
Well, ultimately that has to be done, my lord.
No, I am willing to allow the substitution. That is not an issue.
Substitution. What is, my lord? If my lord allow the substitution, they are already consolidated. I'll be given, my lord, the appointment.
No, here notice has to be issued.
No, my lord. Because notice cannot be issued because they are dead. Substitution.
No. To the proposed LRs, because you are also asking for your prayer contains 4127 also, or to 4127.
No, that is a separate matter. That will be already copy served, my lord, last date. Copy served. My lord said then, my lord, that it will be heard at this same time, my lord. At the time of
normally at the time of final hearing it is
decided. That is that.
So where is the
only point is substitution to be allowed and constituted the approval number to be given because earlier there be another substitution made. So that is the confusion will be. That's just why constituted the approval number.
Who is applying for the other side in this case?
ସେ ଗୋଟେ ମିସକେସ୍ ଫାଇଲ କରୁଛନ୍ତି ସେଟା ତ ପରେ ହେବ ସେ ମିସକେସ୍ ର କପି ଦେଇନା ବୁଝି ନା ନା ଏଇଟା ତ ସବସ୍କ୍ରିପସନ ପାଇଁ ଦିଟା ପାର୍ଟି ପାଇଁ ଗୋଟେ ଆପ୍ଲିକେସନ ଦେଇଛନ୍ତି ତାପରେ ଡେଟ୍ ଅଫ birth ବି nothing is there copy has not been solved
substitution for them it is not necessary because if they are substituted they will automatically compute
order 22 rules for substitution petition file करो settings are at side appointment पर
condemnation of
तीनटा
position so it's a regular you file separate applications I will consider I will liberally consider but you file them This is second appeal, statutory appeal.
My lord.
So why should there be any irregularity?
We do not go to date, my lord. That is what I'm saying. Because the history has pointed out that the notices are unserved. And they are dead.
Notice unserved,
And they, last dates noting, my lord. Last dates noting. We did not know, my lord. Long back it was, notices were issued, my lord.
respondent number 2 being dead.
Respondent number 2 and also 6, my lord.
3, 4, 5, 7, 8 and 9 he got. 2 notices returned being insufficient case of respondent. Now 2 and 6 are dead.
Dead, my lord. Then only you can know that they are dead. And last date it was pointed out. That's why we have filed this, my lord. So that cannot be.
They are members of the same family.
From the same, the second of family. But they are staying elsewhere. The difference, they are not staying in the same place, my lord.
When was this pointed out?
It was not that, my lord. When it came from the history, then only you could know this thing, my lord. Other long back, others have received, my lord, all the notices.
Who are the proposed
My lord, in plus of 2A and 2B.
where have you stated that?
I have stated in the petition, my lord. Para 5, my lord.
His wife.
Sulochana Singh and son Rakesh Singh, and this respondent 6 surveyed by son Hon'Ble Singh. That would replace 6A, 2A, 2B, 6A, my lord.
Since we do not know what we have to say in this regard. Yes.
My lord, but we have not sought the copy substitution petition, we have not sought. दिटा पार्टी मरि जाइछन गोटे पिटिशन में केमती आगे हबो सब्स्टिट्यूशन कंपोजिट हबो जे तापर सब्स्टिट्यूशन लिमिटेशन और सेटिंग असाइड अब तीन टांग पिटिशन देन तीन तीन छह टांग पिटिशन
We'll go for technical. Last time, my lord said that immediately file and do it.
Procedure is
He said, 2017, my lord. It has to be decided finally. It is only technical error that has to be cured, my lord.
All right, we'll take it up. We'll allow it. 439 of 2024. Officer has pointed out that one composite application has been filed seeking substitution of deceased respondent numbers 2 and 6. Stop. Sri Hota, learned counsel for the appellants, submits appellants submits that the appellants came to know about the death of the aforementioned respondents only when the notice issued by this court returned unserved
and distributed
with the endorsement regarding their death and was pointed out by the office. Stop. Respondent number 2, it appears that respondent number 2, it is stated that respondent number 2 has died leaving behind Sulochana Singh and Rakesh Singh. Stop. Similarly, respondent number 6 has died leaving behind his son Hon'Ble Singh. Stop. As regards the objection regarding filing of composite application, it is submitted that this substitution application having been filed after the fact of death of the respondent numbers 2 and 6 being pointed out by the office, a technical view may not be taken. This court finds that the appeal is otherwise ready for hearing. With the other respondents being represented by counsel. By means of this petition, the LRs of the deceased respondents are being sought to be brought on record. No prejudice would therefore be caused to any party if the prayer for substitution is allowed. The IA is therefore allowed. The persons mentioned Sulochana Singh and Rakesh Singh be substituted as respondent numbers 2 bracket small a and B respectively, and Handalal Singh be 6A substituted as respondent number 6 bracket small a in place of the deceased respondent numbers 2 and 6. Notice
notice consulted रखला पड़ेगी consulted appeal memo filing matter and having a copy of the consulted copy also. I'm sorry.
Counsel for the petitioner files consolidated appeal memo in court after serving copy and then counsel appearing for the other respondents,
amending the constituted minor to a
consolidated constituted
minor
appeal memo will go.
Then constituted unit affiliate hitula ସେଥିପାଇଁ it will be confused. So total
consolidated appeal memo amending the constituted.
Yes. Amending the minor stop.
Issue notice to the newly added to the substituted respondents bracket 2A bracket 2B and 6A by registered post with AD. Returnable within 4 weeks. Requisites be filed within 3 working days.
Right.
Is this matter vacation for us?
Well, after vacation,
24th June. In the week commencing 24th June.
Well, not immediately. Little later. 4 or 5 days later.
Week commencing 1st July.
1st July. I've solved the copy matter. But kindly be noted.
After serving copy will let question. Yes.
I do not see.
Obliged.
May it please, your lords. My lord, the poor person could not pay the court fee. In the meantime, the same has been paid. This may kindly be accepted.
What about the limitation then? SR has to be made again?
No, I had filed a petition for extension of time. Since that is pending, question of that petition is to be allowed since in the meantime it is paid. It is to be extended till the date of payment.
Apart petition like an application for injunction under section 149 of CPC for payment of balance.
এটা ভুল হয়েছে अगर मैं নিজে দেখে যাও করি পারলে ওটাও দেখে যায় আই বাহুটা
considering the submissions and the grounds raised, to pray for extension of time to file with the court fees. To pay the court fees is allowed. The court fees are stated to have already been filed, already been paid, this can be accepted.
Can be considered for admission.
Now, right now, we can.
Yes. My lord, may I submit? My lord?
Yes.
Yes. My lord, the defendant is the appellant before your lordship against confirming judgment, my lord. And suit for injunction, plain suit for injunction without title also can be filed, your lordship. No, this way, that way, decision is there, my lord. But it is between one question or other question, one brother against other brother. My lord, petition has been made. My lord, the plaintiff said that
the petition suit.
Partition suit, no. If the injunction, simple suit for injunction, permanent injunction.
Yes.
So plaintiff, my lord, has left 100 feet to 20 feet a vacant space for the purpose of construction of the cow shed. A defendant said no vacant space has been left. It is his property. It is under the boundary wall of the defendant. It requires identification. Minus identification. In the plaint also, no case map has been annexed. No commissioner's report. Case has been allowed.
What is that? Order 8 Rule 3.
Order 26.
No, Order 8 Rule 3 identification. Order 7 Rule 3. No, Order 7.
And also, living issue has not been decided. My lord, here also that point could have been sorted out by deputing a commissioner also under Order 26 Rule 10. That
what is the finding?
Finding is issue number 3. Your lordship can say absolutely.
Whether the defendant be permanently going over the suit.
Finding.
Evidence due to the facts of the plaintiff trading was also proved the ROR.
Yes, may I just.
Plaintiff is the recorded tenant of suit schedule.
The other witnesses examined by the plaintiff is on perusal of the oral evidence and the ROR. It found that the plaintiff is the recorded tenant of the suit khata number so and so. Measuring is situated along with the other plots total measuring fund. The defendant needs evidence. Also stated the plot numbers are different, having khata number 1910 of Mauja Kanai very begs to the plaintiff. He has also admitted that plot number 274 of khata number and plot number khata number are two separate plots. So having gone through the evidence oral and documented, it is forthcoming that the plaintiff and the defendant have no dispute between them as to the ownership of the suit schedule property, which is plot number 274 400. Having holding number 19/10. The undisputed ROR Exhibit 1 also reveals the same. There is no evidence that the defendant has encroached upon the suit land. Though the defendant has contended that he has never tried to encroach upon the suit land, it is right of law that the civil suit is to be adjudicated on the principle of preponderance of probability. The fact that the defendant has landed property adjacent to the suit land, there might have been some disturbance between the plaintiff and there might have been some disturbance between the plaintiff and defendant regarding the suit property. Be that as it may, be put when the defendant is not claiming.
So since you are not challenging the title of the plaintiff, you are
only identification, that ground.
IA number
499 of 2024.
is not there.
Just one day back, one earlier.
IA number takun.
IA number 499 of 2024.
All right, pass over. Pass over.
Item number 9.
I am the appellant in this case.
Who's for the other side? You are for the appellant.
I am for the appellant.
Who's for the other? Anybody appearing for the other side? We'll take it up. 2016 matter, I will not wait. Yes, please.
This is a confirming judgment.
Yes.
I was dependent in the trial court and appellant in the first appellate court.
This has not been admitted. This has been admitted.
Yes. By the order 28/6
because the court will are correct in observing the mother guardian of the minor printing and executive settled on the ground same distance. Yes. What is the fact?
The fact is that the respondents, while they were minors, they purchased a piece of land through their mother guardian. And that mother guardian also sold the land to me in the year 2001. They purchased the land in the year 2006, 96 and sold it to me on 11.08. While the first brother, that is Sanjay Kumar alias Manav Ranjan Khuntiya, became major, he filed a civil suit alleging that the transaction is void because the self-produce has not been utilized for our benefit. The defendant and myself appeared and filed WS stating that the mother guardian was even though the father is alive and the father consented to the deed and consented to is a witness to the salary and the self-produce has been properly utilized for the benefit of the minors. That I have also taken
this time that there was misgender of necessary parties and
Misgender means?
non-necessary parties.
Non-gender whom? Who are to be implicated as parties?
The mother
Mother was alive?
Mother is alive.
Okay.
She is the best person to say how he bought the property in the name of the son and how he sold, why he sold the property of the minor son. She is the best person to say. And she is the best person to explain how the money has been.
So the suit was decreed?
The suit was decreed.
Let us see the trial court judgment.
My lord.
Yes. The issue relating to non-gender. Issue number 3.
Issue number 3.
And then issue number 4. Whether it is a void document. Let us see. Issue number 3 take organ.
1, 3 and 6 reply college as because no evidence is laid.
Evidence regarding what?
The non-necessary party. This is the evidence. Non-necessary party.
Let us see that. তারপরে 4 or 3 বুঝবা non-gender কোটি আছে as no evidence having been laid by either party the affirmation do not require for adjournment. আচ্ছা 4 and 5 এর কোন হোল্ড করলে what was the finding?
First appellate court.
No, what was the finding of the trial court?
There is as because as per section 8 2 of the minor guardianship
and guardianship yes.
The document is void. And so the suit is allowed. But my contention is to that effect is that first of all, my humble submission is the suit is unmaintainable on the ground that out of the 2 brothers, the brother number 2
What is this?
It's a judgment, a trial court judgment.
I have it in me. Don't worry, I have. All the else here. Yes. Position of questionable why?
Our submission is that the respondent number 2 in the appeal.
Who was plaintiff number 2 in the suit?
Who was plaintiff number 2 in the suit?
Yes.
Was a minor when he filed the suit.
You are not represented by him.
He was represented by his brother who attained majority. But law says, unless and until the person attained majority, he cannot challenge the transaction. This is reported in AR 1994, Bombay, page 152 to 155. Para 7 today, correctly deal করাই।
Yes.
My second
what is the judgment?
Again?
What is the judgment you are referring to?
AR 1994,
yes.
Bombay, page 152 to 155.
And he being still a minor, he could not have.
Yes, he could not have filed the suit. My challenging the transaction made by the mother guardian.
Yes, then?
My second submission is that.
Can we go step by step? So what was the finding? Was it raised before the first appellate court? Whether this ground was raised? It's a confirming judgment, sir. It will not be reopened.
It is a matter of law. So it can be raised at any point. I don't know whether it has been raised or not.
Anyway, what is the second ground?
My second submission is that in the plaintiff claims his claim basing on the Hindu minorities and guardianship act.
Section 8.
Section 8. But neither in the plaint nor during his trial in his evidence, they have taken the stand that they are Hindus. I mean, please have a glance to the copy of the plaint. Nowhere they have stated that they are Hindus and they are governed by such school. So if they have not stated or not, neither stated nor deposed in evidence, how they can claim relief under the Act, Hindu marriage and Hindu
No pleading or evidence?
No pleading. Mother can act as a guardian. If the parents, with consultation with the understanding of the between both parents. In that regard, I rely on the decision reported AIR 1999, Supreme Court, page 1149.
Well, this is a factual aspect. Whether there was an understanding between the lady and so that evidence has to be laid.
Yes.
This is a purely factual aspect. What we are saying is that provided it is pleaded and proved,
yes,
it has to be pleaded. Have you taken that plea in your written statement? Because you are saying that the mother is a necessary party. Fair enough.
Yes.
Fair argument.
Yes.
That she should have been pleaded. She is the best person to say how, why she had to sell the property and how she had applied to sale proceeds.
Smiling.
Whether it was for the interest of the minors or not. Because as per the Hindu minority guardian, it has to be applied. The sale proceeds have to be applied for the benefit of the minors.
Benefit of the minors.
So your claim is that, or their claim is that it was never utilized. Now you are saying that the mother acted as a guardian.
Yes.
With the understanding of her husband. Just said you are. But have you pleaded? Have you taken that stand in your written statement?
No, I had not. I had not.
First appellate court को जीवा. First appellate court को judgment को जीवा.
First appellate court simply confirm the.
No. This is.
पढ़ी चले प्रेस
पूरा ना पढ़िया दरकार नहीं खाली मेन जगह टा कहते हैं The following points needs consideration.
Mother?
They frame the points. Whether the sale of suit property of minors without permission of the prior competent authority is valid. The mother of minors is competent to sell the suit property for minor children. Whether attestation by the father in the alleged amounts to conveyance. Question of legal necessity in this.
All points para ten points.
But the non-joined party was never taken.
They were not taken.
Confirming judgment.
They were not taken out of it. But I have taken this stand in my written statement.
In your written statement? Let us see your written statement. See, you खाली जो suit is bad for non-joined or misjoined party से एमित अलग होगा नहीं. Specific plea ना हो. You should have taken a specific plea. Anyway, so this is the point. What is the finding of the additional district judge?
Say 8-2. That is
8-2. But that's a clearly point of law. All right. We'll again continue tomorrow. Third part. Tomorrow, because the other side is not appearing, I'm giving one chance. Otherwise, tomorrow I'll close it. Matter I've understood. I've
चारटा जिनसे मतलब देखिए हिंदू
चारटा जिनसे आपण कहले
आगे
देखिए के तरह हम देखिए आपण जा कहले मु सब टिपिक अछि टिपिक कंफर्मिंग जजमेंट अगेन विथ योर वास्ट एक्सपीरियंस यू नो यस अरे पास और करे काली की you please come tomorrow. If it doesn't come, I'll complete it. Close it. Yes.
11. And on behalf of Swanti, next week, she has some personal.
All right. Next week, as paid for 2018 matter.
Yes,
yes.
I know it's.
We commencing 29. How much is next week?
I don't know 12.
12. Yes.
Yes, Mr. Marty, we meet after a long time. Yes. He has been admitted.
Yes, yes.
Whether the courts
In
below.
the last occasion, one more question of law was also framed by in the earlier bench.
Yes, yes. No, ପ୍ରଥମଟା କୋଉଠି frame ହେଇଛି ଦେଖିଦେବା ତାପରେ whether the courts below has gone wrong in law in holding that the unregistered agreements are admissible in evidence, though not as instrument of title, having failed to notice as definite in a counterclaim is categorically admitted, possession has been delivered. এটা বুঝি হয়নি তো বুঝিবা difficult হଉଛି whether it can be collateral used for collateral purposes. See, you setup.
Two agreements for sale are there.
No, what about the other Honorable Justice Das? Yes.
That was made
Whether the
on
courts
the last date itself.
before entitling the respondent to a decree of specific
53A, ready and willingness.
Oh, ready and willingness, right.
That may not come if I succeed in the first question, because my first ground of challenge is the agreement in question. There are two agreements.
Why don't you say the facts? Facts.
Yes.
Who's opposing you? I'll not wait. Don't worry. I'll not wait. 2018 matter.
One chance may be given. I don't so stand on the way.
No, I'm giving. Just now I gave chance till tomorrow. I will hear you. I'll make it pattern. And tomorrow I'll close it if it doesn't appear.
Okay.
So what was the suit? You are the plaintiff. You are the plaintiff. Sole plaintiff.
Two plaintiffs are there. The plaintiff number one, they are the father and the son. Plaintiff number one, he was Chittaranjan Meher. Two is the Hrishikesh, originally Hrishikesh. He expired in the meantime. He was the father of the plaintiff number one.
Yes.
So both of them filed the suit. There are two items of properties, Schedule A and Schedule B.
Yes.
The Schedule A property was recorded in the name of plaintiff number one.
The problem is I'm not getting the plaint. See, the problem which is scanning, that is a problem. LCR Tachiki. Hard copy is no. Counter claim, written statement, where is the plate? Unless you see the plate, it's difficult. Can you please just explain?
There are two schedule of properties. Schedule A belongs to the plaintiff number one. Schedule B belongs to the plaintiff number two. Both the plaintiffs, they by two separate agreements for sale, executed in favor of the defendant, agreed to sell the property. Schedule A by plaintiff number one, Schedule B by plaintiff number two. There was a condition that he will get appropriate permission from the consolidation authorities for transfer of the property. Thereafter, registered sale deed will be executed. But subsequently, they have pleaded that the permission could not be obtained from the consolidation authorities. As it is, there is no provision for any such permission, but that was the ground taken.
Why permission? Why schedule cost?
No. Fragmentation.
Oh, fragmentation.
There was no provision for any permission by the consolidation authorities. Anyway, there was the pleading like that. So the sale could not be effected. Therefore, plaintiffs themselves should notice to the defendants that there is no possibility of any sale. You please take back your money and the contract can be rescinded. The defendant did not respond. Thereafter, the plaintiffs came forward with this present suit, claiming that this contract should be rescinded because of this condition.
So this is a rescission of contract?
Yes.
Okay.
With the prayer that I am prepared to pay back the money.
Okay.
So the proposed transferors have come forward with the suit. Here, while appearing in the suit, the defendant, they denied the plaintiff allegations and they made a counterclaim for specific performance of contract.
So virtually the same thing as the plaintiff has played. Almost.
No, plaintiffs claim rescission of the contract.
Okay.
Because they say that
at the same time, return of money.
Return of money. Now the defendants come forward with a plea that no, I don't need return of money. This contract may be specifically performed by the plaintiffs.
Okay.
Enforcement of the contract.
Enforcement of the contract.
Yes.
Right.
So at one point of time, the suit was decreed. That was an earlier occasion. The suit was decreed by the learned trial court.
Your suit.
Suit was decreed and the counterclaim was also dismissed. Thereafter, the defendants, they carried appeal. In the appeal, the learned lower appellate court, he framed two questions and remanded the matter back again to the trial court for decision. There, the specific ground, the question was issue was raised whether these two agreements for sale, which are admittedly unregistered, can be enforced so that a specific performance of contract can be decreed.
I get it.
So after that, the other question was of course that permission by the constitutional authority that was not very much necessary. On the question of that as to whether the agreements need registration, and if it is not unregistered, whether it can be enforced or not, the learned lower appellate court comes to a conclusion that even if it is unregistered, it is enforceable and has granted specific performance contract. That is under challenge. Now, before I will place the judgment of the learned lower appellate court, but before that, let me kindly find the two agreements for sale, Exhibit A and B.
Exhibit A and B. Exhibit A, Bikri Chuktipatra, Chitarangan Meher, Sodani Meher.
Two lines are there and just.
Okay, 18/7/2009 था? हाँ, 18/7/2009. Yes.
Exhibit A, the same language is also there. At page, the second page of the agreement.
Second page, yes. Biborani.
Biborani, the subparagraph. प्रथम पक्षଙ୍କ साहुकारी ऋण टंका परिशोध व्यवसाय ପାଇଁ ଟଙ୍କାର ନିତାନ୍ତ ଆବଶ୍ୟକ ଯୋଗୁଁ ଉପରୋକ୍ତ ଖାତା ମଧ୍ୟ ତଫସିଲ ମୁତାବକ 15 ଡିସମିଲ ଜମିକୁ କ୍ରେତା ଦ୍ୱିତୀୟ ପକ୍ଷଙ୍କ ଠାରେ 27,500 ଟଙ୍କା ମୂଲ୍ୟରେ ବିକ୍ରୟ ସୂତ୍ରରେ ଚୁକ୍ତି କରି ଆଜ ଦିନ ବିକ୍ରି ବାବଦ ସମୁଦାୟ 7,500 ଟଙ୍କା ଭଦ୍ରଲୋକଙ୍କ ସାମ୍ନାରେ ଦ୍ୱିତୀୟ ପକ୍ଷଙ୍କ ଠାରୁ ଗ୍ରହଣ କଲୁ। ବିକ୍ରିତ ଜମିର ଦଖଲ ଦ୍ୱିତୀୟ ପକ୍ଷଙ୍କୁ ମଡ଼ାଇ ଦେଇଅଛୁ। That means under the agreement itself, the possession has been delivered. The same language in the exhibit 2 also.
Exhibit B.
Exhibit B, sorry.
18/7/2009.
Page 2 of that agreement.
দ্বিতীয় পক্ষকে গ্রহণ করলো, বিক্রিত জমি দখল দ্বিতীয় পক্ষকে মড়াই গেল।
So undisputedly under this agreement, the possession has been delivered. Now these two agreements are being executed in the year 2009. Now just for the lordships.
Notary.
Yes.
Notarial certificate is there.
Unregistered, admittedly also unregistered.
Yes.
Registration Act section 17(1)(a). Kind of.
Registration Act.
This amendment to the Central Act came in the year 2001.
Registration Act. Please read it.
Yes, 1A. The documents containing contracts to transfer for consideration any immovable property for the purpose of section 53A TP Act of the Transfer Property Act shall be registered if they have been executed on or after the commencement of the Registration and Other Related Laws Amendment Act 2001, and if such documents are not registered on or after such commencement, then they shall have no effect for the purpose of the section 53A. Section 53A specific portion of the contract. Therefore, a document coming under this clause, if not registered, cannot be taken into consideration for the purpose of section 53A and cannot be enforced. This amendment came in the year 2001. Now both the documents have been executed in the year 2009 subsequent to this. Similar amendment also was effected so far as Orissa state is concerned in the year 2002. The same language has been incorporated. Now, in view of this position, the submission before the London Lower Appellate Court was that these two agreements are not enforceable because the agreements are unregistered. This was right back in the year 1953 also. 58 Supreme Court. This and the conclusion was there. If unlisted documents can be enforced or not.
It cannot be enforced, but there is a decision that it can be used for collateral purposes.
And I don't dispute there. Collateral purpose means the possession, etc.
But because there is a question of possession here. That is what you have pointed out.
Possession is admitted because 53 the section. I mean,
So you admit that.
yes, because possession has been delivered. Section 1A, 17(1)(a) comes into field.
All right.
That line would not have been there. I would not have taken resort to section 17(1)(a). Once under the agreement itself, possession has been delivered. Section 17(1)(a) comes to picture, and therefore it is compulsory registerable. If not registered, it cannot be enforced. So this is the first judgment on Honorable Apex Court. Para 14, last part, the line is there.
Para 14. Yes.
The facts have been stated. After quoting the facts of that case, the ultimate line from the bottom around 8 lines from the bottom, the sentence beginning in the present case. In the present case, Harnam Kaur had been in possession before the date of our document, and to admit it in evidence to show the nature of her possession subsequent to it would be to treat it as operating to destroy the nature of the previous possession and to convert what had started as adverse possession into a permissive, and therefore here it is important to give effect to the agreement contained in it, which admittedly cannot be done for want of registration. Because here also the document was required to be registered. What is not honest? So once a document which is required to be registered but has not been registered, it cannot be used for any purpose. That too for the purpose of section 53, where there is a specific bar. Therefore, this at least my suit, I am not concerned in my suit. My suit has been dismissed. At least in the counterclaim, the learned courts will could not have granted specific performance contract because both the agreements are unlisted. Now the learned lower appellate court comes to a conclusion that even if it is unlisted, it can be enforced.
Let us see that judgment.
Yes, no, I am coming to that. Now, here also, the lower appellate court comes to a conclusion: possession has been delivered.
The judgment dated 8th February 2018.
Yes.
Yes, yes.
8 February 2018.
Yes. You have not challenged the dismissal of your suit. So only the decree in the counterclaim.
Counterclaim. May I read? It's a huge paragraph. Paragraph 16, starting from page 20, last line.
Yes, there is no doubt.
There is no doubt that law is quite settled that any document conveying right title interest over an immovable property has to be registered as per provision of the Indian Registration Act and also the Transfer of Property Act. But now the question arises whether aforesaid provisions are applicable to an agreement for sale. In the case of Sanso, 1927 Madras, it has been held that document which does not by itself convey property but merely gives a right to call for another document does not require registration. Now this is 1927. The amendment came in the year 2001 only. I would like to quote some relevant portions of the decision cited by the learned counsel for the.
Not relevant at all.
In skipping that.
Because hey, Mr. Mishra, take it slow.
Then section 17 has been quoted.
But this is a pre-amended decision.
All them are referred to pre-amended. Kindly keep also page 22.
Is it a, therefore the conclusion is resolution of suit for specific performance can be based on an unreasonable document.
This is my challenge in the present appeal.
All right. So say, I will not pass that order, but it is her and part tomorrow. Tomorrow, just to give an opportunity to the other
Yes.
side. Yeah. अब गोटे डाको लिखियो कि ऑप्शन में निकल लिखियो
Item number 14.
तो 14
My lord, this is an RSA out of that initially the present petitioner in this case. I am for the respondent wife, my lord. The present.
who's for the appellant?
My lord, he is not there.
All right, we'll take it up tomorrow. We'll call it out tomorrow. Where is Mr. Mishra is there? Yes.
My.
And this has come for hearing for the first time after notice. My friend appeared. May I pray, subject to, if your lordship allows, my lord.
This is a matrimonial appeal.
It's a appeal where the award was 2 lakhs. This appellant husband is not doing anything, but anyway he has to pay to the wife. That has been enhanced to 8 lakhs by applying a method which the reasonable court has been pleased to formulate a question of law whether that.
What is the formula?
Formula is at page that, my lord, I wanted for a.
What is the multiplier method? Multiplier method are you use in motor accident cases?
Yes, ସେଇ ଭଳିଆ ଗୋଟେ apply କରିଛନ୍ତି ସେଟା ମୁଁ ଟିକେ assist କରିବି ତ ସେଥିପାଇଁ କହୁଥିଲି ଗୋଟେ ଦିନକୁ page 24 ରେ.
Oh. Is this matter next week?
Next week ରେ?
Okay.
20 ଏଇଟା 20 ମସିହାରେ ଆପଣ 18 ନଉଛନ୍ତି.
ମତେ ଯାହା ଦେଇଛନ୍ତି ମୁଁ 18 ମିନିଟ ଦେଖିନି ଯାହା ଆସିଛି.
There is one interim order. Wife also not getting anything. So my lord. He was filed one IF application of interim order.
କିଛି ପାଇବନି ତ କହିପାରିବି.
Wife also filed one.
ଏଭଳିଆ ଶବ୍ଦଟା ହଉଛି incorrect state.
As requested by learned counsel for the appellant, this matter will be commencing 6th May.
Grateful, madam. Grateful. এটা interim order ଟା मैं କାହିଁକି
Interim order to continue.
ନାଇଁ.
Item 15.
ଯୋଉ method ଟା ହବ ସେ ପାଇବେ ସେ method.
Item 15. You are the appellant, Mr. Mishra?
Reversing judgment.
No, your name doesn't appear, that's why.
Name does not appear there.
I mean, pardon, my lord. In this case, Mr. Das is appearing, my lord. He has some personal.
Just a moment.
The earlier order.
No, you are Mr. Mishra, you are appearing for the appellant. But the name appears.
Earlier order.
The name. It has not been carried out probably. Let me just check up.
Senior counsels are there appearing. That's why I have not filed my Mokshatnama. Even though I have the.
Doesn't matter. So who is appearing for the appellant, senior counsel? You are there.
I am.
And Mr. Y Das, Ishan Das?
For me.
For you. All right. Then you?
My lord, Mr. SD Das is appearing for.
Oh, SD Das, he had requested for an adjournment.
ଏଥିରେ ଖାଲି ଗୋଟେ question ହଉଛି section 41 of the Evidence Act. ଆଉ କିଛି ନାହିଁ ତା ଦେହରେ.
All 41.
41 whether the probate has already been made and which is unchallenged. Whether that probate proceeding or the probate certificate is
granted by the district judge.
Correct. And if that's so, if a person has already, the land has already been probated in favor of the legatee, can it be a sellable right under section 6 of the Transfer of Property Act? That is the only question.
But Mr. Das had requested for an adjournment. We'll take it up tomorrow.
No, my lord,
Oh,
tomorrow.
you asked for all right. As requested by learned counsel for appearing for the respondents, list this matter in the week commencing 13th May. Week commencing 13th May. Remaining matters will take it up.
Item number 16 there is an endorsement of Honorable Chief Justice to be placed before Honorable Justice C.R. Das. By mistake, perhaps it has crossed.
ये कोई भूल है जी तो see your answer actually तो से भूल कर देखो
Again.
Don't take
There was an endorsement.
Endorsement of Hon'Ble D. Gun, Acting Chief Justice. List this matter before the assigned bench. Before the
interim formal extension can be considered. Interim order is there already. Other side is appearing, that can be considered.
Since there is an interim order,
yes, ma'am.
list this matter tomorrow, before the appropriate bench.
If it is tomorrow.
On Monday,
Tomorrow.
tomorrow হবনি। চিফ জাস্টিস এর এন্ডোর্সমেন্ট পুরো দরকার হবে।
29 মঙ্গলবার না করুন 30
30 on 30th. Yes. Yes, Mr.
Item 20, appeal has already been.
এটা হলো আমার কই জ্যাং গলে 15 জ্যাং 15 জ্যাং গলে এটা 16 গলা আচ্ছা 17 will take
17, there is only 1 day delay in filing this appeal.
will continue tomorrow
Hard.
সারদাবাজি নোটিস যাইতলা
No, first time it's.
নোটিস দিব 1 day delay will be second appeal
Because I understood there is an entry order.
no delay continue internet
See, for the mutation by apply.
speed post ne hoto special messenger ne hoto
आओ जाओ ये तो जाने अच्छी
ମୁଁ କରିବା ତ ଏଣ୍ଟ୍ରି ମର୍ଡର କେମିତି ଦେବି ମୁଁ ଯେତିକି ଜାଣିଛି ଆଜ୍ଞା ଲରେ
जी notice. I don't come across on that line.
there is a specific provision I think order 41 rule 5
Order 41 5.
yes rule 5 তো
Yes, man.
যা মনে আছে আজ্ঞা
Unless delay will condone.
That kind of
specific
provision is there. I admit that.
My lord, another point is also there. To assist my lord.
Huh.
If a lordship will be pleased, delay can be condoned. If the party will appeal, he can seek for variance. So that is also there.
these are not exceptional circumstances
That might be.
that is not exceptional circumstances
Yes, here is a basing on the appellate order. The respondent is trying to record the decline in his name by before the Tosila notice has been issued. I filed the notice. It's an interim order. How? No, 440 I have attached the notice of the Tosila.
oh Tahsildar's notice
Yes, my lord.
so will you issue notice on that you take special notice why don't you take if that is if it is so urgent you can take special notice if you want
That because of interim order, till his appearance, this can be done. I will take notice till his appearance.
all right
No order can.
1050 of 2023 issue notice is the sole respondent
Yes, my lord, sole respondent.
the respondent so take it by speed post
I'll take it.
by speed post fixing a short returnable date leaves this matter ছুটি পূর্বক করো
Convention 13th May.
13th May
Both in both.
sir both are I 440 of 2024 1050 2023 both has common order yes sir.
Till his appearance. Okay. As it was.
Well, had it been a writ application, yes, I could. Second appeal,
Date has been fixed to 13th May.
আমার কে বিগ্রহ তা পূর্ব রকম
We
commencing 6th May.
No, 13th of May. I'll manage this order also. I can show it before it.
Yes, 18th, 18.
Tomorrow. 18 I may be permitted to be on virtual mode, my lords. I just went on an operation on my
Second appeal virtual mode, Mr. Das, no.
No,
Please.
my lords, no, my
We will
only
request
grievance is-
we will request your august presence inside the courtroom.
I have undergone a surgery on my head.
Okay, on your head.
The other day I was there before lordship, but only 2 days before I had undergone a surgery on my head.
Okay,
So it's a minor one. I will be joining your lordship's court, and that will be my pleasure always. But here a second appeal, but my presence without my presence, your lordship can pass an order. The order is respondent number 1 and 3. In spite of notices being served by your lordship's process, it says that the AD has not returned. Your lordship may fix a date. And by that time, I will be okay enough, good enough to be there in your lordship's
No,
court.
notice service returns have not been received.
Yes.
But on 1 and 2, it is returned undelivered with a report of the postal authority, addressee absent. So you will have to take
That is by postal authorities.
Yes.
if your lordship so permits me, unutilized copies may be utilized.
Yes.
And I will give.
Notice on respondent number 1.
And this is for the second time. If I take your lordship's 1 minute time, the notices on registered post is being sent to them for the second time.
Okay.
And the third and
Okay, we'll do one thing, Mr. Das. So tomorrow I'll call up. I'll go. I don't think tomorrow again there will be any time because tomorrow there is also a reference. So we'll take it up. Or release this matter in the week commencing 6th May. We'll consider then. Yes.
Interim order to continue.
Interim order to continue.
I am appearing on behalf of Mr. Sharma, Vigyan Sharma, for respondent number 4.
In 18.
In 18.
You appear. That's all. Item 19.
My lord.
Yes.
Hello, my lord. Actually, in this RSA 391, the present appellant wants to.
Item 19, I am from the appellant, your lordship.
Yes.
If your lordship
are ready,
my learned senior has to argue this matter. If your lordship may take it up tomorrow, your lordship.
Yes. Tomorrow, if it reaches, if it doesn't reach, it will go to the next week. Yes, Mr. Mishra, you are here in this matter. So tomorrow, if there is time, we'll take it up. Otherwise, next week.
Yes.
It's 2023 matter, so we are not in a very hurry. But yes, item 20, Mr. Das.
LCR has not yet come. It has already been admitted, my lord.
All right.
And my learned senior name has been not reflected. He is already entered.
Remind the court below to send the LCR. The name of Sri DP Mahathi be reflected in the cause list, who appears for the respondent. We'll list this matter on in the week commencing. Last week, 13th May. So we have two pattern matters.
May up to
How LCR has been called for. So we'll pass an order. Don't worry, it will not be taken up. 2024 matter, but the old matters are there. So tomorrow also that matter we will, if nobody appears in the matter which we are arguing, you complete it.
Yes, we will.